before they even came to this court. I would therefore request you, my lords, to decline that request. It is quite different from the request made by the Attorney General. Thank you, my lords.
Thank you, Mr. Gatia. And finally, Mr. Keegan.
Your Ladyship, we also, on behalf of the fourth respondent, oppose the attempt by the Law Society to be enjoined as an amicus. And I would like to make two observations in respect to the application. The first one, my lords and your Ladyship, is that in the application presented by their counsel, they do not make similar commitment as was made by the Attorney General, that they propose to limit themselves on issues of law as opposed to issues of fact. That undertaking was not given to you. And it is our view that that's a very significant issue, that the LSK, in our view, has chosen not to make that undertaking. The second issue, my lords and your Ladyship, is that the council has said that the affidavit that was sworn by the vice chairperson was made in a personal capacity. My lords and your Ladyship, an affidavit has been sworn in support of that application, and that distinction is not made in the supporting affidavit. The distinction that the affidavit that has been made in support of petition number 5 was made in a personal capacity is not made in the affidavit, and we think it is a significant consideration. Lastly, my lords and your Ladyship, having been observers and subsequently swearing an affidavit in petition number 5, it is our view that the resources that were employed by the Law Society in the course of the observation of the elections were collated by the said witness in the petition number 5 and used to support the petitioner. And it is our view, therefore, my lords and your Ladyship, that considering all these circumstances, the Law Society would not add value to these proceedings as a friend of the court, but would be using the status of an amicus, if they are allowed, to advance the cause of the petitioner in petition number 5. Thank you, my lords and your Ladyship.
Thank you. We reserve our ruling on this, probably give it later today. Today, yes.
Excuse me, I have a point of objection.
Sorry, just a minute. Omar, just wait. I'm sorry, Mr. Shah, very, very sorry. You have the right to respond, right?
My Lord, it seems that none of my co-members are supporting me. And they're all members of my society. However, my Lord, I wish to make it clear that there is no conflict of interest at all insofar as the body of the society is concerned, and the individual views of the vice chairperson in her personal capacity have nothing to do with the society. My Lord, we're not taking any partisan position, but I will eventually, my Lord, I have no choice but to leave the matter in your able hands, my Lord, and if we are overruled, we will gracefully bow out. Thank you, my Lords.
I have a point of objection, please. I have a point of objection to raise.
Sorry, madam. You are not a party in this matter.
I have a point of objection to raise, and I wish to be heard. I'm properly before this court. I filed my application on the 23rd, which was duly received by the registrar of the Supreme Courts after 2 weeks of lobbying within the courts.
Kindly, madam, please take your seat. Your application will be heard tomorrow.
I'm here as Wanjiko, representing Wanjiko. My application has been accepted by the judiciary, and I can see you've called police officers to throw me out. Please, I will not be bullied. I want to know if the presence of the Chief Justice, the first question I've raised in my application is a preliminary point of law. If it is proper for the Chief Justice to continue on his bench.
Excuse.
Can you listen to the court?
Excuse.
You have made an application.
Yes.
The court has made directions that your application has been referred to the registrar of the Supreme Court to be heard tomorrow morning, and you have been given notice. And you say
I have not been given notice.
You have been given notice. The matter is coming. In fact, this morning you were told by Mr. the clerk here. As far as we are concerned, you are not a party, and you have not been given leave to be a party in this matter. It's coming up for hearing tomorrow.
Yes, no one has been given leave. The AG has not been given leave, nor has the LSK. I have filed properly under Constitution and articles of the I have filed properly under Constitution and want to file an application under notice of motion to do so. And today is the only day to deal with trial conference to determine who is coming on board and who is not. So I'm already been intimidated by police officers. Can I have a right to be heard? I think I have a right to be heard, a constitutional right to be heard. You may decide to throw me out, but I have a right to be heard. I have filed properly. I've paid fees for this. And it has a date. Everyone has been served. All the parties have been served. They are all here to hear my application before this court that the Chief Justice recluses himself. That the Chief Justice recluses himself because of two misconducts on two files that are filed against the Prime Minister who is the
Madam, you cannot take over the court. Will you sit down and get directions from the court? Sit down, please.
Well, how do I raise my issues when
Sit down and hear what the court is saying. I have said you sit down.
Has contaminated this hearing. He is biased to the Prime Minister's interest in two petitions that are filed before the High Court. Petition number 306 of 2011, that is a civil society activism in court by please let me have my name. I think, if you'll allow me, serious.
Kindly, madam, sit down. You'll be heard tomorrow, please.
I need that fairness. My children are outside this court, distraught. Am I going to be forced out of this court? Is this
You will, Miss, you will have to respect the authority of the Supreme Court. You will have to respect the authority of this court. Can you sit down? Can you sit down? Can you sit down? Can you sit down? For the last time, Ms. Umar, can you take your seat? Can you take your seat?
Kindly sit down. Kindly sit down. Please sit down. Sit down kindly. Kindly sit down.
Sit.
Yes. Sit down. Take your seat.
Can you sit down? Yes. Yeah.
Kindly sit down. Please sit down.
Okay. Judge Wanjala?
Yes. Ms. Omar, it is absolutely important and it cannot be negotiable that the authority of this court shall and must be respected at all times by Wanjiku, by the high and mighty. And I hope that is clear. So you will have to go by the authority and the orders of this court. If you expect justice, justice cuts both ways. You don't come to court by your own justice. And this court is ready to listen to every Kenyan as long as they are properly before this court. The rules of court, the Constitution, and all applicable laws are meant to establish order. It is not a political rally. It is a court of law. And it is the Supreme Court of Kenya. So you will have to abide by the orders that flow from this bench. I hope that is clear.
Absolutely clear. Absolutely clear, my lord. But as you said, only the orders from this court can guide. But I've not been heard.
Now
and
this is the order of this court. This is the order of this court. this is the order of this court, that we are not going to hear you in defiance of the instructions that have been given to you by the registrar of the court, and that this court is not going to be held at ransom. This is an important matter for everybody. We are constrained by time, and now we are going to proceed. You defy that court, you defy that order at your own peril.
That the presence of the Chief Justice facing serious controversies in favoring murder of Odinga during the election.
You have no right to say what you are saying. Will you sit down?
Kindly take your seat.
You have been given final orders. Sit down and do not talk anymore. That is it. Do not talk. You have no right to talk. The court has given its orders and it is absolutely final.
Can we go back to the issues, Council? That is C. Yeah, but they didn't. We don't have the application, do we? Do we have that application? We don't. The other two. Which other two? Because we have finished the Law Society. Do we have another application from Kaskuriya?
Yep, we have got an application by Katiba.
When was it filed? We did. Okay, Council, can we get back to business? We're now dealing with the consolidated issues for determination. We've looked at your responses. What I'm going to ask the leading counsel is whether there are some issues that are left out or some issues that you want to add to the issues that have already been given to you. And that's pages 4 to page 7. So, Mr. Ringeru, on the issue, on the, yes. We didn't get it. Was it? Do you file it and serve it to everybody who is here?
It has been filed in petition number 4, but we made clear there that if there is consolidation, then we would like to participate in all the issues.
It was, yeah, we only got 2 applications from the AG and the LSK, and actually they came here for mention last week, and we asked them to file the application and serve every party, so that we would have the kind of process that we've gone through here. Yes. So that's why it's not listed. Do you want to speak?
If I may be obliged, Your Honors, for the record, it's Waiko Wanyoike. I'm one of the directors of Katiba Institute. We did file, and we have copies that shows that the application was filed on the 22nd of March, 2013, and we have already served all the parties on petition number 4, because this is based on petition number 4, as Professor has explained. This morning, I actually did get an indication from the registry that the petition was here. I have a copy that shows that it's been filed and that parties have admitted service, except, I believe, for the 4th respondent, when the service was being done this morning, I understand the process server was not able to effect service. So if we may request the court to look at that.
Did you serve all the parties? All the parties, I mean,
no.
The respondents in all the petitions?
No, we've only based this on petition number 4, and so we've only served petitioners and respondents in petition number 4.
Since we don't have it, we'll have to deal with this matter afterwards, and basically deal with the registry and see what has happened. Because we didn't have it, we would have had you.
Okay, most obliged.
Yes.
Excuse me, Your Honors. I also do have, my name is Isaac Alua, Chair.
Excuse me, Mr. Isaac. Your matter will be mentioned tomorrow before the Registrar of the Supreme Court at 9 a.m. in the morning.
Sorry, that communication has only just been given to me. I wasn't aware of it.
Yeah, sorry. I'm sorry, yes. Okay. Okay, Mr. Reguero, please.
Chief Justice, I have gone through the issues as drafted, and it seems to me that by and large, they have captured the issues that are going to be canvassed and determined in these proceedings. And with specific reference to petition number 3 of 2013, in which I am appearing, I note, for instance, that issues number 1 and 2 cover that petition squarely. The issue we raised there is a very neat point of law, and it is sufficiently captured there, and therefore I would have really no objection to these broad issues as drafted.
Thank you. Thank you. Ms. Kilonzo.
My lords and my lady, we have perused the draft issues circulated by the court, and we are in agreement with them. They sufficiently capture the issues arising in petition number 4 of 2013.
Thank you, Ms. Kilonzo. Senior Counsel George Oraro.
We have gone through the issues and we are satisfied that they cover all the issues in our petition and indeed the other petitions that we have raised. Thank you.
Senior Counsel Abdullahi.
The consolidated issues, I think the court has captured. We are not very satisfied that it captures both sides of the argument or the divide. It is basically too much of a reproduction of petition number 5 and number 3. And I think there is need to encompass the issues we raise, especially the second respondent's reply to petition number 5. We are not just limiting ourselves to the issues the petitioner raises. We have gone beyond it. There are a number of very important issues we are raising in our response, and we want that to be captured in the issues once we frame it for our final determination.
You want to draft those? Because we gave this so that people could respond to...
Yes, we can draft and I think give to the court before the end of the day. Is that fine?
Yes.
Yes, we'll do that.
Okay. Mr. Rabello.
I don't take a similar position for the IEBC. We are of the view that issues as drafted appear to have been taken primarily from the petition itself, and probably our response, our entire response, was not entirely available at the time because we had very limited time to file a response. We have filed a very substantial response on all the issues. So this morning we have filed our proposed issues, if the court supports that. But perhaps
have you served all the parties?
I'm not sure because we finalized it and filed it in court this morning.
Your colleagues here, so that when we come back, we see whether they have any objections. And
that's right.
I think, Mr. Abdullahi, the same thing. Whatever you draft, Senior Counsel Abdullahi, whatever you draft to give to your learned brothers and sisters, so that we can quickly incorporate those issues.
Yes, I'll do that. But even the issues that the court drafted, there are some issues we think do not fall within the jurisdiction of the court. And also we will highlight that because...
We were going actually, after we've gone through the issues, we're going to start the process of narrowing down. We know there's a lot of duplication in a lot of those issues, so we're going collectively to narrow down to the real issues that we should look at.
By then, the drafts from our perspective will be with the court.
Okay. Yeah, 3 p.m.
I know I'm not yet the friend of this court, but may I suggest something that may probably help us to move forward?
Yes.
Which is to impose an obligation on all counsel to sit together and agree on the issues and come back to court only with a list that is either largely agreed on or where there are very, very few issues left which the court will now settle.
Okay.
Just to point out that the AG is not yet a party to these petitions. You have not yet been admitted as amicus curiae. We appreciate those sentiments, but let us follow the order that we have set as a court.
Mr. Ngatia.
Yes, my Lord Chief Justice. Let me also, my Lord, say that the issues drafted by the court do not really capture all the pleadings. But perhaps let me start from a different angle. We are concentrating, so to speak, on petition number 5 for obvious reasons. Petition number 5 is founded on Article 138 as well as Article 140. And that, by definition, would be the first problem, because Article 138 and 140 are not interchangeable. They are different legal regimes. Having said so, we must also look at a more preliminary issue. What are the issues which can legitimately be canvassed before the Supreme Court? Because that would be the beginning. What are the issues which legitimately can be canvassed in the Supreme Court within the auspices of a presidential petition, be it under Article 138 or Article 140? So there are certain of those preliminary issues, my Lord Chief Justice, that require to be attended to. I then proceed to give... sorry?
When do you intend to raise them? Because the essence of this process, the way we understood it, was that we send out these issues to all counsel, and they'll look at them, and if they wanted to rephrase them, they wanted to add some more, subtract from it, so that we had a collection of issues, and then we will deal with the preliminary issues that you're talking about.
The checklist, my Lord, didn't give us so much discretion as you have now given us. Mm-hmm. Actually, we were battling this with my legal team, whether you have authorized us to redraft the issues. And we came to a unanimous decision that you haven't given us any such authority. But having said so now, my Lord, I will suggest the following. Mm-hmm. That you allow us the remainder of this morning to get together as counsel. We are under obligation to assist this honorable court.
Yes.
We all get together. Or the 3 consolidated petitions. Okay. We are looking at 3 to 4 issues. But, my Lord, again, because I do not want to be caught on that word of honor and then I fail, Petition number 3 is a standalone petition. Standalone because the issue it raises is just one legal issue. So while as we say we are consolidating it, it is consolidation for purposes of hearing. The 2 other petitions are the ones capable of being consolidated so that we subsume all the legal issues in one petition, and possibly we agree petition number 5 to be the lead petition for purposes of hearing. But all those are things that we may be able to resolve if you so direct that we all get together the remainder of the morning and see how far we can get on with it.
And buy all the council lunch, Mr. Gatia, after you're done. Yeah, I think it's sensible.
Yes.
It's sensible. We should do that. We have no objection to doing that.
Very well.
And when we get back at 3, is it 3?
Yes.
Then
we look for the most neutral chambers to sit, because other chambers may not be as neutral as they should be.
Okay, so Mr. Keegan, are you happy with that?
I am.
You are? Okay. I skipped the issue of the proposed consolidation of the, the 3 petitions. Can we go back to that? Mr. Gatia, you had touched on it, but let me just follow the order that I've been following. Mr. Ringeru, on the issue of the consolidation of the 3 petitions.
Yes. Thank you, Chief Justice. As far as consolidation is concerned, I do agree with my learned senior, Mr. Ngatia, that our petition number 3 is a standalone petition. It does raise a very neat and limited point of law as to whether the rejected votes ought to have been factored in at all, as the IEBC counted and tallied the presidential count. And so it seems that that is a petition that can be dealt with in isolation of the other 2 and be disposed of that way. If there should be any objection to that, then we can always address it. But the general principle of consolidation is, of course, sensible. It does expedite matters. It does save you time, cost, and so on. So generally, we are open and we are agreeable to the issue of consolidation, subject to the observations we've made about petition number 3.
Okay. Ms. Kilonzo?
My lords and my lady, we are not opposed to the consolidation of the petitions. In our view, the law and facts raised in all the petitions lead to the same question, whether or not the election was valid. And we feel that in view of the constraints of time, the matters of fact and the matters of law should be addressed simultaneously.
Thank you. Mr. Oraro?
If it may please you, my lords, I do not think that petition number 3 can be consolidated with the other petitions because it is predicated on the tallying process. It is not a petition under Article 140, notwithstanding the collusive nature of the response, which requires this court to endorse the results by IEBC. The only suggestion I would make is, because of time, it can be heard together with the other petition and one decision made, but I don't think it can be consolidated. It is not a petition for setting aside the results of presidential elections, yes.
Mr. Rebello.
My lords, we have no objection to the process, to the petition being consolidated to save time, the court. I know that the court will treat petition number 3 separately, as it has its own limited issue, but it can be heard together with the other 2 petitions quite conveniently.
Mr. Abdullahi.
I don't really repeat what my learned friends have said, but I think a consensus has emerged on this issue that whereas petition number 3 is distinct in light of the peculiar sole legal issue it raises, I think the proposal by my learned friend George Oraro is the right one. We can hear them together, give each one of them their distinct character. But I think in terms of hearing, we can have one hearing and address the issue in petition number 3 separate from petition number 4 and 5. And I think someone have said that really the petition that should carry the weight of the other petitions, or which we should consolidate the others, is petition number 5. That is the main petition this court should hear.
Mr. Gatia, you addressed us on that. Please just recap.
Indeed, my Lord, I'll be very brief. Why I refer to it as a standalone is because of the reasons which have now emerged. It's unique in itself. It could be heard within the purview of that petition.
Yes.
Then we go to petition 4 and petition 5. Issues are similar. Contest is similar. Engagement is similar. Because of all those similarities, petition 4 can be submerged and be a subset within petition number 5, so that further process Ms. Kathy's client together with Mr. Leonard Senior Counsel's client. The respondents remain the same. So it is indeed viable to consolidate those two, but the other one becomes a standalone. But all of them heard all together. But that, my Lord, I think I need to say, two distinct judgments will therefore arise, not one.
Yeah. Mr. Keegan.
My Lords and your Ladyship, it's my view that petition number 4 and 5 can be consolidated and petition number 5 be the lead file. It is also my view that petition number 3 should be heard separately, or rather be heard in the same instance, but be treated separately.
Okay. Yeah. Thank you. See now. I think nothing arises out of it. Nothing arises out of evidence as far as I know. Let's, although we didn't get any comments from Council on this form, so we appreciate what Council Gatia is saying, that you interpreted the form in different ways. So shall we look at E, the evidence then, and see whether there are any issues that...
Before we reach E, there is the issue of interlocutory application. And we have one pending interlocutory application.
Oh, your application?
Yes, thank you.
Okay. Okay, let me just finish this. Oh yeah, this is the one.
Madam friend,
yeah.
Mr. Cheng will address the issue.
Okay.
May I please, my Lords, Honorable Chief Justice.
How long will you be, Mr. Cheng?
My Lord, 3 minutes. 3 minutes.
Oh, great.
My Lord, the Chief Justice, judges of the Supreme Court, fellow counsel. My Lord, the motion before the court is the one dated 19th of March. My Lord, it's been filed within the context of petition number 5 of 2013.
Can we find out whether you served everybody?
My Lord, I did serve the parties involved in petition number 5.
Number 5.
There is a return of service on record.
Okay.
Yes, I do.
There appears to be some little problem in my team. Learned Counsel Mr. Ogeto, who is on record, says that he has not been served with this motion.
Yeah, because when we had the mention, right? Our view that everybody who is appearing, you know, in all these petitions should have and should be served with these applications so that they, although they are not directly involved, but as we've already talked about consolidation, and so our view is that all council should be served.
Most obliged, my lord.
Yeah. Do you want to serve them? We could take it up in the afternoon.
My lord, I'll serve.
Yeah.
Immediately.
Yeah. Okay.
Lord, pending the ruling, can I have your permission to leave the court?
Definitely. Definitely. Yes. And whoever else wants to leave, we can do with extra seats. Okay, so what were Mr. Odro, you serve, and then at 3 we will hear you.
Most obliged, my lord.
Okay. So let's look at the Part E. Part E, that is the evidence. So if there are any additions, Mr. Ringero, I start with you.
My lord, my lady, as far as the tables they are concerned, we were required to input in those columns as indicated.
And you did, yes.
And we did,
yes.
Specifically on items 5, 8, 17.
Yes.
Yeah, that's it. And also other documents we've given some indication. So we've already given our input as far as this questionnaire is concerned.
Actually, have they been given this document? Have you been given this consolidated document that has your responses? What you're saying, Mr. Rigero, is that you responded, and
Yes,
we've
to
actually
the questionnaire.
compiled.
Yes.
Do you? We've compiled the responses of every party in this document.
Oh,
you haven't seen it.
That yet.
Yeah, I think we should.
Maybe if that could be circulated by the
okay.
registry.
Okay, so everybody should assume that we got your responses on the question of evidence. If there is anything that you think has been left out, you can let us know. Ms. Kilonzo?
My lords and my lady, we have indicated in the checklist the documents we shall be relying on.
Okay.
But this morning we've also filed a notice to produce, and we've served it on the advocates for the first and second respondent. And my lord, I don't know whether I can address you on the issue or whether we can deal with that issue in the afternoon.
Can you tell us what it's about? Yes.
My lords, at page 8, item number 11 is the voters register. You will notice in petition number 5 of 2013 and in the replying affidavits of the first, second, and third respondents, all the parties, that issue has been raised on what register was used during the presidential elections. My lord, we will be making an application that the marked register, both the principal register produced in court for scrutiny. But we can address that application later, or if you allow us, right now.
Mr. Yeah, just address us. Sorry, Mrs. Nyamondi, right, yeah?
Perhaps, my Lord, if I may be of use to the court and my learned friend.
Yeah.
The information sought by the learned counsel for the petitioner in petition number 4 are annexures to the replying affidavit in petition number 5. So perhaps what I can do is undertake to serve her with that affidavit when the court breaks, and if she requires any further information, she can then make her application when the court reconvenes after that.
My Lord, I don't think Mr. Nyamodi understands the import of my inquiry. The register that we would like produced by the Independent Electoral Boundaries Commission is a register that was marked during the elections conducted on 4th of March 2013, and which under the regulations was forwarded by the presiding officer to each returning officer of the 200 copy. We are asking for the manual marked register.
Mr. Nyamondi?
My Lord, that register runs to 750,000 pages. That register is resident in 33,400 ballot boxes spread out throughout the country. I will take instructions from my client how long it will take to produce the register, but the commission, if so ordered, will be willing to produce it. But it will take some time to get, because the register is disseminated to every polling station. And after voting, every polling stream, and after voting, it is sealed in the ballot box.
You talk of some time.
Where is the principal register?
The principal register is divided into several parts. And for the purposes of the election, it is the principal register referred to in section 4(1)A of the Elections Act. And that is then distributed to every polling station. So at this point in time, the principal register is in the presidential ballot boxes in respect of each polling station. The marked register.
Issue might, I see quite clearly that everybody needs to be involved. It's not just between you and IEBC. So I suggest you also serve everybody and we can hear it.
My Lord, with your permission, if I can be of assistance to counsel for the Independent Electoral Boundaries Commission, the regulations require that the marked register is put in tamper-proof sealed envelopes and delivered to the returning officers. That is the regulations. So it is not true that it is sealed in the presidential ballot boxes, unless you're saying that they did not follow the regulations.
Yes, the exchange comes to an end. Serve that application, make sure that everybody has a copy of it, and then we will revisit that, in the afternoon. Mr. Oraro, on the issue of evidence.
We have specified the evidence we intend to rely on,
yes,
and we'll abide by that.
Okay.
And in the event that there's any further evidence, we'll notify the court in good time. Thank you.
Good, yeah. Mr. Rebello?
Your Honors, we have completed the questionnaire at E, evidence, by supplying a separate attachment listing every document that we have produced. There wasn't enough space in this document.
Okay.
So we've done it.
Okay.
And we abide by it.
Okay. Mr. Abdullahi?
My Lord, I associate myself with the sentiments by my learned friend Rapello, but I think this court probably needs to address a broader issue, which is the mutating nature of the petitions, especially petition number 4 and number 5. I mean, these petitions were brought in a certain form and with certain factual metrics. I think on Friday we were served with a huge document that will require both the IEBC and my client to put in a further affidavit. We are now hearing that the fourth respondent will put. Can this court give us directions on the nature of the petitions the respondents are facing. We need to face a single petition, not a petition that mutates as time goes by or as increases as we reply to those petitions. And I think it will have an impact on the hearing of this matter if you allow the petitioner every time we reply to them to look for more evidence or to fish more. This case will never be heard.
So,
yes, my lord.
What about evidence?
The evidence, when the petitioners thought that their course of action crystallized, they came to court with a certain petition. We answered that petition.
Yes.
I think it's in the nature of these cases that a party normally puts in a further reply affidavit, but we must have a time frame when those issues come to an end. And I think there's a danger that those issues may not come to an end because, frankly, I don't think the two petitioners know what their case is about.
We all thought, or we were convinced that that issue will come to an end today.
I hope so, my lord.
Yes, okay.
I hope so.
All right. Mr. Ngatia.
My lord, I think those comments are unfortunate. The further affidavit filed on Saturday was in response to their affidavit and was answering the very issues they raised with their documents, which they didn't serve up to Saturday. In fact, the documents have been served after we have responded. And that was our final response. And in addition to that, looking at the rules, there is no limitation on providing further evidence with the leave of the court if that evidence is relevant. So I do think that my friends should treat this matter much more seriously than those casual comments.
With respect, Your Honors, if I may just be given one moment, because the affidavits were served on us as IEBC. They were served very late. We had to work very late over the weekend to try to get them responded to. We've got the replying affidavits. We are in the process of filing them. But if
today, I hope.
Today, yes. And if the court would now direct whether it wants or needs any further affidavits.
We'll do that at the end of the day, because I think it will be premature now to...
Yes, we're getting these affidavits and documents being served on us so late, it's becoming impossible for us to coordinate and to respond to them within a reasonable time. And what we would like also, if I may suggest at this point, is if the court registry could supply to us a listing of all the documents which it has received as of today, so that we know whether we are on the same page.
Okay. Mr. Gatia?
Yes, my lord. I apologize. I'll be the bearer of also bad news. The position is as this, my lord, because it's important that this court is aware of it. The petition number 5 raised concerns about 34 electoral areas. 34 electoral areas. We responded to those electoral areas. We made a complete response to it. The merits or sufficiency is now a matter in your hands. On Saturday, another affidavit going to about 900 pages was filed by petitioner in petition number 5. It raises issues regarding 122 electoral areas, new electoral areas. We were served with that affidavit this morning. Mr. Ken Ogeto was served with that this morning.
Does it concern the application that we're going to hear in the afternoon?
No, it is now about the evidence.
Okay.
Because we are on the paragraph dealing with evidence. I raise this, my lord, because it's not just mutating, it's a metamorphosis. Here is a fact situation that was raised by the petitioner, as the petitioner is entitled to. We respond to it. Another new fact situation is raised. I say this, my lord, because at the appropriate time, I'll seek leave for this honorable court to determine whether new complaints can be raised in this honorable court entertained by this honorable court after the time period has expired. But that is only number one. Number two, which is now of immediate importance, is that we cannot say that the evidence is before you. I am now formally seeking your leave, my lord, to respond to the new 900-page affidavit, to respond to the issue relating to 122 electoral areas. And even if I were to work until midnight, the earliest I'll be able to file a response to it will be tomorrow late afternoon, if the registry would still be open. So, for your purposes, my lords, on evidence, what we had filled out on Saturday with my team is incomplete because there will be that other response that we are now duty-bound to make. But we'll make that response without prejudice to a fundamental question whether the petitioner in petition number 5 can be allowed to mutate or his petition to undergo metamorphosis as a response is made to it.
I think you should respond to the affidavit as you have said, and we will definitely hear you on that preliminary point tomorrow at some point.
Very well.
Okay, you say you will do it by 2, so...
No, late afternoon, my lord. Late
Today?
Afternoon. No, tomorrow.
Tomorrow?
Tomorrow, late afternoon.
Mm-hmm.
No, Mr. Ogeto is saying it's maybe not...
Because we just have... Today for pre-conference hearing, and we can take up some matters tomorrow as well, but that will be it.
We'll do our best, my lord, but I do not see us being able to complete it today. There are 122 new electoral areas. If they had been raised initially, would have had an adequate opportunity to respond to them. But having said that, my lord, let me now go to the next point, which is general, and I think it covers everybody. I come from the school of thought that a litigant is perfectly entitled to raise whatever allegation he wants to raise. But there has to be a limit to when those allegations are to be raised. Equality of arms, fairness in a trial require that timelines are set. If the petitioner in petition number 4 also wishes to raise any new thing, they should say so, and a time period agreed, so that I don't want to ever come before you, my lords, and apply for adjournment. Once we have agreed on those ground rules, that the time for allegations is over, time for response is also over, we now engage in the more meaningful exercise of processing this petition, consolidated petition, to a very quick determination. Thank you, my lord.
Thank you. Mr. Keegan?
My lords and your ladyship, we were also served with a 900-page further affidavit by the petitioner in petition number 5, and we would also need time to respond. My lords and your ladyship, it is our view that that affidavit distorts the issues that had been identified and the scope of the issue of testimony and evidence that would be adduced, because we now have to address new issues that have come up this morning after we had filled the questionnaire that the court had asked us to fill in response to the scope of the case. Lastly, my lords and your ladyship, on our part, for the 4th respondent, we would pray that you determine the question of whether or not that further affidavit is properly before you and whether it deserves to be responded to in view of the timeline within which the petition and the full scope of the petitioner's case should be met before we engage ourselves in the laborious task of responding to the 900 pages. We would very much pray that you give us audience on that issue.
Will your lordships permit me to say one thing?
Yes, we just put our heads together. Mr. Gatia and Keegan, I think at 3, if you're ready, you could argue that issue, so that we give a ruling on it.
Thank you.
Before we subject you to replies. Because yes, what I hear you saying is that you want us to decide whether that affidavit is properly before this court.
We'll be ready. We'll be ready at 3 o'clock, my lord, as you have directed.
Okay.
My lords, I don't know whether it is now I would say so or at 3, but I would still say one thing just now, that the advocates for respondents are making the petitioners, now that these matters have been consolidated, to appear as if they are responsible for the change.
We haven't even ordered on consolidation. We had arguments and we said
yes,
we're coming back, because if you remember, there was also a suggestion that although Petition 3 will be heard with the others, but it's a standalone.
Separate, yes, my lord. Yeah, but I'm saying that we are not responsible. Actually, it is the Independent Electoral and Boundaries Commission that has been so slow in providing information, even when it has been sought administratively before. So they must be responsible for the consequences of that being slow. 2, perhaps your lordships will consider this in the afternoon, that my colleagues seem to be mixing 2 things, issues and facts. The new affidavits, and I must confess I've not read the 900-page affidavit, I've not seen it, but if it is raising new facts, if it is raising facts that relate with the issues that have been identified in the petitions, there is nothing wrong with it. If there are new issues which would have required to be part of the main petition, that's a matter that can be distinguished in the hearing of the application rather than engage in any possible sideshows. I'm saying this with tremendous respect, my lord, because time is of essence. The petitioners need these petitions to be determined quickly. I do not think that this court has more time beyond this coming Saturday to deliver its judgment, or to at least to render a decision. Therefore, we must be minded that matters that are intended to reduce the timelines for argument must be restricted and limited to the bare minimum. Thank you, my lords.
Mr. Ahmed.
Yes, my lord.
Sorry. Yeah, it's okay.
I think that order you made should equally apply to the first and second respondent. That is the chairman or the returning officer and IEBC.
Everybody will be asked
everybody,
to...
because
yes,
I think it's a very important issue, as you rightly say, that the petition we have facing now is not the one that was filed when my learned friend filed petition number 5. And I think we will argue that this afternoon.
Yeah, okay. Is that okay? I didn't ask you, Senior Counsel Oraro, is that...
My lord, it is okay we should argue it, because what is happening is my learned friends are attempting to avoid their obligation to address the issues raised in the petition. The issues raised were the issues of tallying and the issues of verification. They then filed a response which was served on me on Thursday evening, confirming how correct their tallying and verification was. We have filed an affidavit from their documents, which we were unable to get without court order. In fact, we had to go to court to get an order to get those documents, and the final copies of those documents were served on us on Saturday. What we have done is annex their own document showing how their tallying was. I don't know how that can fall out of the petition, but we'll address it fully when they put in their case this afternoon.
Sure.
Yes.
Sure. Okay. I think on matters of evidence, I've gone through everybody, right? Maybe at this time we need what is left. Shall we discuss the management of time now? Not yet. Yes, okay, okay. Okay, let's recap. So at 3, we have some rulings to deliver, but we also hearing 2 applications, the way I understand it. Your application, and then Mr. Ngatia's application, 3. I think that's it. That's it. And you're also meeting, I think, to agree on the issues, and Senior Counsel Gatia is going to buy all of you lunch. So we then adjourn until 3.
All right.
Let's use it effectively.
Masharia.
kesi hii kama rafiki wa mahakama. Swala hilo litaweza kujadiliwa ama kuamuliwa zaidi na mahakama ya juu na majaji wa mahakama ya juu ikiwapo saa 9 kamili. Kwa kwamba kikao cha pili kitaandaliwa kuanzia saa 9 alasiri ya leo. Swala lingine ambalo majaji hawa wameweza kuliangazia pamoja na mawakili wa pande zote ni swala la ushahidi. Muungano wa kodi unasema uko radhi kuitisha ushahidi mwingine kutoka kwa tume hiyo ya uchaguzi na mipaka, na unasema kwamba tume hiyo haijakuwa ikishirikiana na muungano huo katika kutoa ushahidi zaidi kuhusiana na yanakujia moja kwa moja kupitia KBC Channel 1 na vile kupitia KBC Radio Taifa. Mpenzi mtazamaji, utakuwa unasikiliza wakati tutakaporejea wakati kikao cha pili hapo saa 9. Kwa sasa hatuna la ziada kutoka mahakama ya juu. Jina langu ni Martin Mwanje, kuna wale wote walioshiriki ili kufanikisha matangazo haya. Kwa sasa tunarejesha hadi studio.
Asante, shukrani sana Martin Mwanje kwa ufafanuzi huo. Kumbuka mpenzi msikilizaji, utakuwa unasikiliza vikao vya pili kwa siku ya leo kuanzia saa 9 mchana. Kwa hivyo endelea kusikiliza Radio Taifa Sauti ya Mkenya na pia vilevile kutazama Channel 1, KBC Channel 1 kwa matangazo hayo kema, ambapo bila shaka wewe kama Mkenya pia vilevile sasa hivi unafuatilia kwa makini mjadala hiyo ama mjadala huu, kisha kwamba unapata uhondo kamili. Kwa hivyo tuko hapa mbele msikilizaji kukujuza mengi zaidi kuhusiana na vikao hivi. Endelea kusikiliza Radio Taifa Sauti ya Kenya.
Ngojea kidogo. Kama tuweke.
Mic check. Mic check.
Where's the assistant counsel? Your assistant counsel.
Very important.
Page what? Mark. Text. Okay, I have. Yes. Okay, how many? How many? How many pages? Without management system. Yeah, got it.
Lordships are here.
Start with the rulings.
Okay, welcome everybody. And we are going to start with the rulings, which the CJ will go through in conducting. Welcome all.
The ruling on the application for amicus curiae will be read by Mr. Justice Ojwang.
Two applications were made before this court earlier in the day, both seeking admission to the status of amicus curiae. The first was by the Attorney General, while the second was by the Law Society of Kenya. The learned Attorney General submitted that the importance of presidential election based on the terms of the Constitution of Kenya 2010 justified the participation of his office as protector of the public interest in the capacity of amicus curiae. The Attorney General submitted that his office had no partisan interest in the matter and would in any case limit itself to such role as the court may approve. He urged that the Attorney General, if admitted as amicus, would do no more than highlight legal questions and in this way provide guidance to the court. Most of the several counsel in the petitions, Mr. Regeru, Mr. Abdullahi, Mr. Ngatia, Mr. Rebelo, Mr. Kigen, supported the Attorney General's application. However, learned counsel for the petitioners, Ms. Oraro and Ms. Kilonzo, opposed the application. While not doubting that the Attorney General would remain non-partisan as amicus, Ms. Kilonzo submitted that, as the case was essentially evidentiary and not concerned with the interpretation of the Constitution, there was no special contribution which the Attorney General could make in the capacity sought. Counsel urged that the government needed not participate in the petition proceeding as amicus, since its role was like that of a respondent via the agency of the IEBC. Learned counsel Mr. Oraro submitted that if the Attorney General was seeking admission to amicus status by virtue of Article 166 of the Constitution, then the application is inappropriate, since the proceedings are of a sui generis kind and are not civil proceedings. Counsel urged further that by current statute law, the Attorney General has an advisory role in the transfer of power from one state officer to another, and it is precisely this function which is contested in the petitions. After considering the several lines of submission by counsel, we have taken note of certain governing scenarios which lead us to a final decision. Firstly, the State Law Office, the chief officer of which is the Attorney General, is the custodian of the legal instruments of the executive branch and the recognized advisor of the state in matters of public interest. Secondly, and interlinked with the foregoing point, the said office is the main player in the performance of the executive's role vis-à-vis the operationalization of the Constitution. Thirdly, the Constitution expressly provides that in certain instances, the Attorney General may obtain the court's permission to appear as amicus. Fourthly, the court, which is the custodian of rules of validity, propriety, and fair play under the Constitution and the law, remains in charge in regulating such precise role as the Attorney General may play if admitted as amicus curiae. These considerations have led this court to the conclusion that it would be improper to exclude the Attorney General from the role of amicus in these proceedings, and that admitting the Attorney General to such a role will not present a condition prejudicial to either the scope of the court's authority or the best interests of the parties to the several petitions. We find the position of the Law Society of Kenya to be entirely different. The submissions of learned counsel, Ebisha, in favor of admitting LSK to the status of amicus were by no means the most powerful, but our position has been conditioned more by the common direction and focus of the submissions made by learned counsel. The effect of Mr. Shah's submission is that since by Section 4 of the Law Society of Kenya Act, LSK is mandated to assist the government in matters relating to lawmaking, this is a typical case in which LSK deserves to be admitted to the status of amicus curiae. But the argument to the contrary is more powerful. Learned counsel, Mr. Geru, submitted that an affidavit in aid of one of the petitions sworn by the vice chairperson of the LSK left little doubt that LSK had taken a partisan position. And this same point has featured in the submissions by other counsel as well. LSK's application is opposed by learned counsel, Ms. Kilonzo, who perceives the applicant's role as partisan, Mr. Oraro for the same reason, Mr. Kamau Karori for the same reason, Mr. Rebelo for the same reason, Mr. Ngatia for the same reason, Mr. Keegan for the same reason. The court's position is now expressed in the following orders. A, the Attorney General is admitted to the status of amicus curiae in the petitions before the court. B, the application by the Law Society of Kenya for admission to the status of amicus curiae is disallowed. C, orders are made accordingly.
My lords, I wish to thank you.
The ruling on consolidation will be read by Justice Ibrahim.
Thank you. This is the ruling on consolidation of the petitions. We have considered the question of the possible consolidation of the three petitions, namely petitions 3, 4, and 5 of 2013. We have carefully considered the submissions by counsel regarding this issue. All these petitions are in respect of the same respondents with regard to one matter, the validity of the presidential election of the 4th of March 2013. As we have indicated, it is that time is of the essence in the disposal of these petitions, which relate to matters that touch on great public interest and on the Constitution of Kenya, which is the supreme law of the land. We agree with counsel that petition number 3 of 2013 raises distinct and separate questions to be determined and is a stand-alone petition. However, we note the need for expeditious disposal, the time constraints, pressure on the court, and many complex matters to be determined. We are of the view that the three petitions should be consolidated as one petition. This means that petition number 3 of 2013 will be heard within the consolidated petition and the questions therein determined without prejudice to the parties. We hereby, therefore, order the consolidation of the three petitions. The file for petition number 5 shall be deemed to be the pilot file in which all proceedings shall be recorded and the final decision made therein. Accordingly, petition number 5 of 2013 shall be referred to hereafter as the first petitioner. The petitioners in petition number 4 of 2013 shall be jointly referred to as the second petitioner. The petitioners in petition number 3 of 2013 shall be jointly referred to as the third petitioner. The respondents shall remain as set out in petition number 5. Orders accordingly.
After getting the documents last week, we've gone through these documents as a court, and Judge Wanjala is going to give that ruling, with some ruling of making suo moto, is it in Latin? Okay, suo moto.
Having been seized of the three petitions challenging the presidential election of 2013, and having carefully studied the pleadings therein, the court hereby makes the following orders. 1, there shall be a scrutiny of all Form 34s which were used by the Independent Electoral and Boundaries Commission in tallying the presidential vote from each of the 33,400 polling stations in the country, including the Forms 34, which were used by the IEBC in tallying what is now commonly referred to as the diaspora vote. Number 2, the scrutiny shall aim at establishing the number of registered voters, the number of valid votes cast, and the number of rejected votes as indicated on each form. 3, there shall be a scrutiny of all Forms 36 which were used by the IEBC in aggregating the tallies of the presidential vote from all the Form 34s. 4, the scrutiny will aim at establishing the accuracy or otherwise of the total tallies of the presidential vote as indicated on the Forms 34. The scrutiny shall also aim at comparing the number of registered voters indicated in Form 34 and the number of registered voters on the principal register. What constitutes the principal register shall be addressed in a couple of minutes for purposes of expediency. 6, there shall be a retallying of the presidential votes in the following 22 polling stations using the Forms 34 and Forms 36. I can quickly read the 22 polling stations. 1, Lokosowian Primary School, Lomerimeri, Lontolio Primary School, Nairobi, not Nairobi, Nairobi Primary School, Mumone Primary School, Ntambiro Primary School, Kabutio Primary School, Mailitatu Tea Buying Center, Mtuuma Primary School, Mugumoni Primary School, Kingatua Primary School, Pililai Trading Center, Sango Primary School, St. Andrews Primary School, Kabitoi Dairy, Boron Primary School, Don Bosco Primary School, Magenji Primary School, Chepkolon Primary School, Kapkurongo Primary School, NCC Social Hall, Koitabut Primary School, and Kamobon Orthodox. Those are the polling stations, but the constituencies from which the polling stations, in which the polling stations were situated, are also annexed to the list, which shall be given out. The retally, the principal register, that's number 8, shall be used in this exercise is the external hard drive presented by the IEBC in their annexure AIH.9 in the replying affidavit of 1 Ahmed Isaac Hassan. Number 9, this exercise there is number 7, which I have been graciously informed by my brother judge that I had missed. The retally shall aim at establishing whether the number of votes cast in each of these 22 polling stations exceeds the number of registered voters as indicated in the principal register. 9, this exercise shall be carried out on the 26th of March 2013 from 8 a.m. at a place to be designated by the registrar of the Supreme Court, and it shall be notified to all the parties by the registrar. The results of this exercise shall be filed in the Supreme Court registry by latest 4 p.m. on Wednesday, the 27th of March, 2013. Number 11, the petitioners shall each jointly or shall jointly appoint 10 agents to act as observers during the scrutiny exercise as per orders 1 to 6 above. 12, the respondents shall jointly appoint 10 agents to act as observers during the scrutiny exercise as per orders 1 to 6 above. And 13, an oath of secrecy and confidentiality shall be administered to each and every one of these designated agents referred to in orders 10 and 11 above for the purpose of carrying out this exercise. The oath shall be administered by the registrar of the court on the 26th March 2013 at 7:30 a.m. The venue of the oath shall be communicated by the registrar. It is so ordered.
Although we've talked about the principal register, but we want the IEBC, Mr. Nyamondi, to basically address us on that issue, because what we are saying, what you gave us is a hard drive and what else? Yes. Hmm?
And there is the register.
Yes.
Of voters whose biometric information was not captured.
Okay. So what you gave us, does it include the biometric, non-biometric? What does it? What?
It only includes those voters whose biometric details have been captured. It does not include the non-biometric details.
What you gave us?
Yes.
So where do we get the non-biometric data from?
We can supply that.
When?
As soon as it's up.
Okay.
I think it's important for you to supply the court with all the documents you consider to be the principal register. So not just the CD-ROM. You need to give us the biometric, the non-biometric, and any other document that constitutes what you're calling the principal register. And also supply to all parties.
Ms. Kilonzo, your application will be coming later, and you will argue it.
Okay.
We wanted to give that ruling, which is a court ruling on this issue as we understand it.
Okay.
But now I'm going actually now to deal with the application. Is Mr. Alucheri here?
Most obliged.
Okay, Mr. Alucheri. You wanted to join application, to be joined in petition number 5, is it?
I applied to be enjoined to petition number 4, the one where Ms. Kathy Kilonzo is the advocate.
Number 4.
Yes.
And I understand that your applications have been rejected. You had applied to petition, it was rejected, right? Can somebody give him, Judge Ibrahim, give Mr. Alucheri the history of his matter?
I can explain the past proceedings in which Mr. Alucheri has been involved in. The first one is so that, because we got mixed up in the morning, so we told you to go tomorrow to the registry, but actually one application is pending here. The first application we dealt with was for Mr. Alucheri filed a pre-poll petition challenging the presidential election. It was dismissed, and we reserved our reasons to be given on 27th of March. However, because of time constraints and this petition, we are going to give you notice tomorrow as to when we'll give the reasons. Then Mr. Alucheri came back and asked to be given leave to be admitted, to be allowed to file a former pauperis, or rather, to file a petition as a pauper through former pauperis proceedings. It was disallowed. But now he's come back today, and he's filed an application to be given leave to join as a co-petitioner in petition number 4. So the court would like to know whether you have served on all parties concerned, and whether you have consulted even the owner of the petition, the petitioners in 4, and whether they have given you leave even before the court considers that, and for the application to be heard today in a very brief proceedings.
Thank you very much, Your Honor. About a week ago, I think on the Monday, immediately after the declaration of the president-elect, I came to court and I presented my papers filing the application. The court formally received it on the following day, which is Tuesday the 19th, I believe, and I've basically been waiting for directions from the court since then. Immediately thereafter, I did file and inform the petitioners through the advocate, Kilonzo and Company advocates, of my application, and I've also served all the 20 potential respondents in my particular application. I've even filed an affidavit of service, which I believe was filed on Thursday in court, so everybody has been served. The only party that hadn't been served was in petition number 3. I believe the advocates is advocates, but today I did have a chat with Counsel Njoroge Regeru, and I've sent them by email. I've served everybody. So right now, as it stands, everybody who's involved in the petitions has been served. And it's only Njoroge Regeru and Issa who was served today, but everybody else was served as of Thursday last week. It was all complete.
Okay, in your words, what is the core of your petition? The application. What is it
the
that you want?
As opposed to, essentially, sorry, if I may ask for guidance, are you asking me why I want to be co-enjoined as a co-petitioner?
Okay.
I mean, basically...
That's what you want?
Sorry?
You want to be co-joined?
Yeah, I want to be co-joined as a co-petitioner.
Okay. Why?
The reason for that is I raise issues, constitutional, weighty constitutional, other legal issues, and even evidential issues that have not been raised by the other petitions filed in court. Petition 3 is very simple, dealing with rejected ballot papers. Petitions 4 and 5 are pretty similar, touching on tallying issues. 5 is a bit more extensive, even deals with issues of the voter register beginning even prior to the election. The issues that I raised deal with the qualifications of the candidates, whether they were qualified to take part in the elections in the first place, under Article 137, and also Article 77.2, again, a qualification issue, which is a Chapter 6 matter. These are issues that no petitioner in the 3 petitions filed in court has raised. In the interests of justice and in the public interest, any matter that affects the legality, that affects our Constitution, should be heard. And considering Article 48 talks about the state shall ensure access to justice for all persons, that is why even if I was blocked in one route, I went to the law, looked for another route to ensure that these weighty constitutional issues are presented before you, honorable judges, that you may consider them together with everything else. There is no point us saying we are following a constitution, yet we ignore some very weighty, pertinent matters that also should be considered in the collectivity of everything as it is being considered. My petition is very brief on evidence and facts, because evidence is very simple. Were the state officers qualified or not? You simply look at their status. This was their status when they presented the nomination papers. Qualified, yes or no? It's very simple. Facts, basically, in my petition, 3 paragraphs of facts only. The rest is just the legal issues, whether or not they should have been allowed to take part in the presidential elections, and if they shouldn't have been allowed to take part in the presidential elections, whether it is in order for the election of the president-elect to be invalidated. And I don't just talk about the election of the president-elect, because the issues that are raised concerning the president-elect also concern 6 of the presidential and deputy presidential candidates, 4 presidential and 2 deputy presidential. And therefore, in the interest of impartiality, lack of favoritism, if the issue touches on one candidate, it should also touch on all the other candidates. So in essence, Article 137 and Article 77.2 that have not been raised by anybody, those are the reasons why I've come before this court, that the court may consider these weighty constitutional issues and come up with a judgment on the matter. In essence, that is why I stand before this court.
Thank you very much, sir. Mr. Regeru. Yes, sir.
Thank you, Honorable
Yes.
Chief Justice. The first point is that we have not seen this application at all. We have not been served. It is true that the applicant did approach me soon after the court rose, and he requested my email address, which I gave him. But between then and now, I simply haven't seen that application. But going purely by what the applicant says, I can have one or two comments. Number one, he seems to zero in specifically on petition number 4. Now, we are not parties there. I know they've been consolidated, but we are not in that petition. Secondly, there must be a reason why he zeroes in on petition number 4, presumably because he identifies some close nexus between the issues raised in that petition and what he wants to articulate before the court. But then he very quickly contradicts himself by saying that he wants to introduce brand new issues that have not been raised in any other petition. So by his own admission, he seeks to advance before your lordships a brand new petition, if you like, on brand new issues not anywhere canvassed in any of these other petitions. And it seems, therefore, that logically, rationally, he's out of time. On that ground alone, then, there may be little benefit in admitting him to petition number 4, therefore, in the consolidated body of petitions, if that is going to have the effect of introducing a brand new cause of action in the petition that has not been articulated anywhere else. He is hopelessly out of time, and I think in the interest of time, he needs to be disallowed, and we carry on with what is on right court.
Thank you, Mr. Regeru. Ms. Kilonzo.
My lords and my lady, I do confirm that we were served via email.
By the way, I wanted to tell you that,
yes.
you know, you don't have to wear that gown, and yeah. You can just wear a suit, because you're going to start sweating in here. It's very hot.
Thank you, my
But
lords.
it's up to you, right? Yeah, just in case you didn't know, in the Supreme Court, gowns, wigs, and whatever are not, just smart suits.
I'll be guided
Yeah.
by you, my lord. Thank you. My lords and my lady, we were served with this application via email, and after taking instructions from the first and second petitioners, we advised him that we would be opposing his application to be joined to petition number 4, and we also served him electronically with a copy of a replying affidavit of a first petitioner, Gladwell Wadhoni Otieno. My lords, it is my humble submission that the Constitution and the Supreme Court presidential petition rules are very clear on how a party who is aggrieved with the conduct of presidential elections should approach this court. My lords, if the applicant had any grievances, he should have filed a petition within the 7 days required under the Constitution and followed the elaborate rules and procedures of this court. My lord, the issues the applicant seeks to raise and to join in our petition have no nexus to the clear grounds and evidence that the petitioners will be presenting in this court. What they will only serve to do is to cloud the issues and to muddle the evidence that the petitioners have brought before this court. My lord, it is my humble submission that the applicant and the petitioners have no nexus whatsoever, and it will be prejudicial to the petitioners for the applicant to be joined to their petition, because as the petition and the evidence will show, they have been involved in the electoral process, not after the results were declared, but long before, in conjunction with civil societies and in conjunction with other arms of the government. I therefore strenuously oppose that application.
Thank you. Mr. Oraro?
I really have nothing useful to add to what Ms. Kilonzo said.
Okay. Thank you, Mr. Oraro. Mr. Rebelo?
Likewise, Your Honors, I associate myself with what has been said by counsel.
Mr. Abdullahi?
My Lord, we will oppose this application. I don't think it will add any value at all. I mean, we have 30 lawyers from distinguished background. What we cannot elucidate, I don't think a layman here will elucidate. I don't think it will add any value to this matter.
Mr. Abdullahi, this format I've been told, this is a very, very brilliant layman.
There are many, many brilliant lawyers. The point I'm making is, my Lord, I think in all fairness, even the issue he's raising of Article 77 has no relevance in this matter.
Yes.
An election petition, there are only 4 constitutional provisions, 140, 138, 137, 136. So, but if he wants us to raise some issues, I think one of the lawyers surely can raise for him.
Mr. Ngatia?
For the record, my Lord, nothing useful to add to that which has emanated from my learned friends. Thank you.
Okay. Lastly, Mr. Keegan.
Nothing useful, my Lord, to add. I have nothing useful to add, my Lord.
Okay.
May I request you, my Lord, now that I am a friend of your court, to include me among those people whose views you may seek. And assuming, my Lord Chief Justice, that you have given me, I was just going to say, Chief Justice, nothing useful to add.
A ruling on your matter tomorrow. I'll give you 2 minutes, yes.
Thank you very much. With respect to comments by Council Regeru, that the issue is out of time, I was here on the Monday immediately after the declaration of the President-elect and made my application, as Your Honor Justice Ibrahim has mentioned, on an informal papyrus basis, and I attached my petition. If that application had been accepted, probably mine would have been the first petition that would have been admitted over here. So it is not a question of dilatory tactics on my part, no. I have made every effort to do everything by the law. The only challenge was that I didn't have the cash on hand at the time the petition were being filed, and that is why I was applying on an informal papyrus basis. With respect to comments, but that also answers the issue raised by Ms. Kilonzo concerning filing within 7 days. That was done on the basis that I've just mentioned. There is the issue of clouding issues in Petition 4. I think that has been overtaken by events since you've already ruled on the consolidation of the cases, and even with respect to Petition number 3, which is going to be considered in isolation, the principle applied to Petition 3 can also be applied to the issues that are raised over here. On the issue of Council Abdullahi, no value added, I think it needs to be reminded that I'm not applying as a friend of the court. I'm applying to be enjoined as a co-petitioner. I have issues concerned with the qualifications of the candidates for the presidency of this country, which are constitutional requirements which have to be complied with. We cannot say and just dismiss the issues that I'm raising as irrelevant when they concern our constitution, which is voted upon by the people of Kenya, and therefore it is in the public interest. The issues here, I think, which you have to weigh is the issue of public interest versus private interest. The interests of the various petitioners seem to be private. The issues of the respondents of those particular petitions seem to be private. I brought these issues here before this court in the public interest, that the private issues which they haven't raised, but which the people of Kenya passed in the Constitution of Kenya, should be considered, and therefore the matter be considered in the public interest. If the AG, who's supposed to be the defender of the public interest, hasn't raised the issues that I've raised, and our Constitution allows anybody, any Kenyan citizen, to raise these particular issues, I believe this court, being friendly to every Kenyan, irrespective of status, should actually admit this particular issue that I'm raising, that they be considered, dealt with, and we have a proper, validly elected president, fully compliant with all the laws of this country. There is no point saying we dismiss or accept this petition based on A, B, C, D, E, yet we know fully well, and your honorable judge is fully aware, the issues are raised cannot be wished away. they should be considered in the public interest and in the interest of justice. And with respect to justice, then where else in this land of Kenya can one go to for justice? This is a place for justice. I've come here, whether I'm a rich man or a poor man, is actually irrelevant. Justice sees nobody. Justice doesn't see a rich person or a poor person. It's the issues of law brought before this court that should be considered. And if public interest outweighs narrow private interests, and if the issues can be accommodated, just as petition in the same line as Petition 3, I believe this matter should be had before the court and let the court make a judgment that will encompass all the issues of law that should be considered without ignoring basically the elephant in the room, so to speak. Thank you very much, Your Honors.
At 9 for your ruling, okay?
Thank you very much.
Okay. Professor Yashgai. Yes, it's...
I apply on behalf of the Katiba Institute.
Yeah, we wanted to know, Professor Yashgai, if that application has now been served on everybody.
Yes, it has been.
It has, okay. Yeah. Okay.
Shall I continue?
Yes. Yes.
Katiba Institute was established about 2 years ago with the aim of promoting knowledge and enforcement of the Constitution. Since then, we have published numerous articles and held many workshops to increase knowledge of the Constitution. But more relevant for this particular application, the Katiba Institute has been admitted and acted as amicus curiae in a number of matters in the Kenyan courts, including the High Court, Court of Appeal, and the Supreme Court. For example, we were admitted recently by the Supreme Court of Kenya as an amicus curiae in Advisory Number 2 of 2012, a matter that dealt with the application of the two-thirds gender rule in Articles 27 and 81, as well as the interpretation of Article 1.4, which relates to petitions to the Supreme Court concerning a challenge of the election of a president-elect. Katiba Institute and I myself were amicus in the case relating to the determination of the dates for the general elections that was litigated in the High Court and the Court of Appeal and the Supreme Court. If I could briefly indicate the scope of our submission, which is now ready to be distributed, were we to be admitted as amicus, we intend to limit our participation concerning the matter at bar to commentary on issues of law, including the content, contextual and historical framework of the relevant constitutional provisions, the interpretation to be given to the various relevant constitutional and statutory provisions, relevant international and foreign law, and the range of constitutional and statutory remedies available to the court. I think that's all I need to say, unless you have some questions.
Yeah. Thank you, Professor. Mr. Regeru.
Thank you, CJ. I've just been served with this application not too long ago. I've just been perusing it as Professor Yash Palgai addressed the court. And I think, in fairness to my clients, I would like to take a little more time. Why? To investigate whether there might be any conflict of interests with Katiba Institute. We do know that Professor Guy is a prolific writer, has written extensively, publicly, and so on. And I think, in fairness to my clients, we would want to dig a little deeper into the issue. Should we be satisfied that there is not any potential conflict, we'll be the first people to say. If there is a conflict, we will indicate to the court. And we can do this as early as when we resume fasting tomorrow morning.
When do you want to start the digging?
The moment we are released from here, we will begin to dig below.
Tomorrow morning, that's what you're saying. Okay. Yes. Yeah. Ms. Kilonzo.
My lords and my lady, in view of your earlier ruling on the application by the Attorney General to be joined as a friend of the court and the principles you've laid out in that ruling, we will not be objecting to the application by Katiba Institute to be joined as a friend to the court.
Mr. Oraro?
I would really not object to the Katiba Institute being joined as a friend of the court, subject to very clear guidelines on what contribution each amicus can make to the court without interfering with the very tight program which you have.
Mr. Rebello.
Your Honors, I would welcome the participation of Professor Yash Thalgai, provided that there are very strict limits to his participation in view of the very strict and difficult timelines that we have. Perhaps if Professor Yash Thalgai could limit himself to a written submission, a brief to the court, that might be very useful. I'm much obliged.
Senior Counsel Ahmed Abdullahi.
My learned friend who is assisting me in this matter will address the court on this issue.
No, he says this. He said.
My Lord, the Chief Justice and the members of the court, I've also just seen this application now. In fact, I've borrowed a copy from my learned friend here. So we haven't been served with this application yet. The issues that have been addressed by my learned colleague, particularly the role that they will play and the partiality or otherwise that they will play in this matter is very crucial. And for that reason, I would want time to seek instructions from my client and respond to this, and therefore I think I will be able to do that in the course of the day, and then we'll address this issue tomorrow.
Yes, may it please you, my Lord Chief Justice, my Lords. Over lunch hour, I was served with a copy of this application. Invitingly, it shows an institution that has no partisan interest. But gone are the errors of first appearances. I request time to seek instructions from the third respondent as to whether this institute has undertaken any activity that would debar it from being an amicus. I cannot assume on face value that it hasn't. I would have no such authority. If you allow me that window, my Lord Chief Justice, by tomorrow morning, I'll indicate the third respondent's position, and if we have no difficulty, I'll indicate we have no difficulty. If we have, I'll present the material before the court.
My Lords and your Ladyship, I requested time also to take instructions. I will refer tomorrow morning.
So Mr. Regeru, Mr. Ngatia, and Mr. Keegan, you have the time. We can hear you tomorrow at 9. Okay. Thank you. We now hear Mr. Oraro's application.
May it please my Lord, the Chief Justice and judges of the Supreme Court, my names are James Ochieng Odwo. My Lord, before you is a notice of motion dated 19th of March 2013. My Lord, this application was filed on the 19th after the petition had been filed, and principally we seek disclosure of certain electronic logs. My Lord, I must confess that there's been substantial compliance with some of the things that we asked for, but there is still outstanding the electronic logs in the various servers that were used in the process of election. My Lord, if you look at page 28 of the affidavit of one Dismas Ongudi, there is an illustration of how the result management system was working. My Lord, Mr. Ngudi does not disclose empirically why the transmission system failed. But my lord, all servers have got logs, and those logs will tell you if there's an error, the error will be noted. If there is an event log, it will tell you which event took place. And my lord, if there is an error, that error will be classified and will be stated clearly in the log. So my lord, we seek from the IEBC, as detailed in paragraph 2 and 3, and my lord, their service providers, Kencall EPZ, Lantec Africa, First Technologies, Next Technologies, Google Kenya, all the logs of the various activities undertaken for and on behalf of the IEBC. My lord, this request is not out of the blue, because the IEBC, in its mandate, has got a constitutional and statutory mandate to establish and conduct an electronic electoral system to comply inter alia with the principle of free, fair elections, which are administered in an impartial, neutral, transparent, efficient, accurate, accountable, and verifiable. So, my lord, this is an obligation of the IEBC to provide those logs. My lord, no prejudice will be suffered by the IEBC if those logs are provided. And my lord, if you look at page 28 of the chart that I've referred you to, you will see that they had handheld devices which were connecting to the internet. Those devices have got IP addresses, or they've got media access control. My lord, there are 6 servers which they used at the headquarters. There is headquarters server number 1. There is also another server at the constituency tally center. There is also another server at the county tally center. There is also the national tally center server, and then there is the backup. My lord, all we are asking for are the electronic logs on those servers. My lord, those servers will tell us whether or not there was a transmission through the service providers, what time it was transmitted, whether it was a successful transmission, whether there was an error, what was the nature of the error, so that we are able to verify what Mr. Ngondi has stated in his affidavit. That's my application, my lord. I therefore ask, my lord, that you allow prayers 2, 3 of the notice of motion that is before you.
And I forgot to ask whether you served all colleagues there.
But I did serve the application.
Thank you. Mr. Ringero.
Thank you, CJ. Although the orders sought are really directed at the IEBC and its chairman, in view of the consolidation of these proceedings, obviously we have a right to say 1 or 2 things, and we do have 1 or 2 points to make. And you do notice, my lords, that if you look at a wording of those 2 prayers sought, 2 and 3, they are to the effect that they be given all this information, or whatever they have limited it to facilitate a forensic audit of the first respondent's IT system prior to the hearing of the petition herein. So that is really the order that they want, to conduct a forensic audit of that IT system of the first respondent prior to the hearing of the petition. Now, the questions that must engage your minds with respect, my lords, is, number 1, who is going to carry out this forensic audit? And let me say that these questions arise because you cannot possibly be acting in vain. You want to be making orders that are effective and productive and that are useful to this process. So legitimately, you would have to ask yourselves, who is going to be conducting this forensic audit? Number 2, who would participate? Is it only the applicants, their agents? Is it all of us? Which leads on to the third question, which is, on what terms of reference would the forensic audit be conducted. And another question that naturally arises is, who would be bound, or would this court be bound by the outcome of that forensic audit, or what is its intended purpose? Because again, we don't want to be engaged in an exercise of futility. And finally, because everything here is time-bound, you would have to consider really what time is there between now and Saturday to conduct any kind of forensic audit, which has to be done and produced before the hearing of the petition. So we would have to first allocate time for that forensic audit, get whatever results on whatever parameters, then we begin to address the hearing of the petition. With respect, my lords, we do not have the luxury of time. Time here really is cast not just in stone, it is cast in steel. We cannot extend it. And from a practical, logical viewpoint, I do not see how these orders can possibly avail to the applicants who bring them at this 11th hour when we are at the trial conference. We want to get on to the substance of the matter. Interlocutories, this would derail the very elaborate timetable that you have so painstakingly set to ensure that, in fairness to your lordships as well, that there is enough time for us to articulate our cases and enough time also for you to consider and to deliver your decision. On those considerations, it would be my submission that these prayers have no basis, they have no merits, there is no justification why they ought to be given. They should be rejected, and we get on to the substance of the petitions before us. Thank you.
Ms. Kilonzo.
My lords and my lady, I wish to support the application filed in the first petition. My lords, part of the prayers in petition number 4, prayer number E, mirrors the order that the petitioners in the first petition are seeking. What is more fundamental, my lords, is Section 82 of the Election General Regulations Act that makes it a mandatory requirement of the electoral process for the Independent Electoral Boundary Commission to transmit results from the polling station to the constituency tallying office electronically. It's a mandatory requirement. In their replying affidavit, the second respondent admit that Parliament amended the regulations. The regulations that are taken to Parliament couched that requirement in permissive terms that they may transmit electronically. Parliament, in its wisdom, provided the word shall, making it mandatory. There are admissions before this court that that obligation was not carried out by the Independent Electoral Boundaries Commission in 55% of the polling stations. The issue of the electronic transmission of results is an issue in both petition number 4 and petition number 5, the first petition and the second petition. It is my humble submission that the reasons that the Independent Electoral Boundaries Commission have given for the failure of this system is not sufficient, and they are obliged under the Constitution to be accountable. That means responsible and answerable. Those logs that the petitioner is requesting for will go to show why there was that failure. And more importantly, if that failure vitiated the validity of the presidential elections. I think it is important. The question whether these logs should be produced and what the court will do once the logs are produced is independent. They cannot be mixed together. It is important that this evidence, which is material to the determination of this petition and which is in the custody of IEBC alone, should be produced for the court and Kenyans and the parties to inspect. That is all.
Mr. Rebello.
The response for the IEBC will be made by my friend, Mr. Nani Mungai.
Nani.
Thank you, my lords, the Chief Justice and members of the court. The IEBC opposes the application. We have filed grounds of opposition and a reply in affidavit, which was filed on the 23rd of March. The application before you is not an application seeking for logs, as has been characterized by my learned friend, Mr. Ochieng-Oduor. The request for logs is just one of 23 items that are sought under Prayer 2. The request for logs is Prayer 2O only. What is the application before you? The application before you seeks, first and foremost, a forensic audit. Secondly, it seeks that the IEBC produce physically all the equipment that was used in the election. The phones, the 33,000 phones, the laptops for BVR, the 14,000 of them, the EVIDs, the electronic video identification devices, 33,000 of them, and all the servers that were used in the process. So when you go through the application, you will find that what we are being asked to produce in 2 days is the entire ICT infrastructure of the IEBC. Once that equipment has been delivered to the petitioner, they then seek information that will enable them to undertake the forensic audit. So when you look at the prayers that seek the MAC addresses, the media access control addresses, the IP addresses, that is the information that will enable them to access the equipment once it is delivered. And then they also ask for all the passwords. This is prayer number 2G. So essentially, they are saying, bring all the equipment, bring all the information that will enable us to do an audit, and then give us the passwords. They are not concerned with the actual data, because the data has been provided. So in respect of the BVRs, what data did it have? The register. That has been already provided. In respect of the results transmission devices system, all the information that was transmitted, all of it from 14,000 polling stations has been exhibited as DO4 in Dismas Ongondi's first affidavit. So the data is actually there. The only concern they have is that they're saying, we don't know whether this data is actually the correct data. So bring all your equipment and let us then interrogate it. So for you to give them the information, that is the logs and the MAC addresses and the IP addresses, you need to give them the equipment as well to be able to undertake. So the first question that this court must ask is there a legal and factual basis for undertaking a forensic audit? And we submit that none has been laid. The second thing that you need to consider, my lord, is that a lot of the information that is sought is totally unnecessary and irrelevant to the issues in petition number 5. For example, they have asked for all the BVR kits, the ones that were used for registration. So the question you need to ask is, if they were brought before this court and given the passwords and you entered in, what will you find in there? You will find the raw data of the registration. But you not only have the raw data of the registration in the provincial register, which has been produced in court here, but also the certified one. So essentially, they are asking you to audit the entire registration process and try and find out what were you doing with this particular BVR kit. Totally unnecessary and absolutely irrelevant to the entire process. The other point you need to consider is the dangerous precedent that would be given by this order. Essentially, you have a petitioner who has come and said, I lost the election, I think it was because the equipment may have been tampered with. So if you order that every time somebody loses an election and is dissatisfied with the result, they can order a forensic audit, the IEBC will have no equipment. Then there's a logistical issue. Where is this equipment that they seek? It is in 17 warehouses all around the country. This is the equipment that the IEBC uses for all its elections. If there's going to be a by-election, they will be using this same equipment. But they want all that equipment brought here for forensic audit, essentially destabilizing the operations of the IEBC. My Lord, one then wonders, what is the motive behind this application? Because the information itself with regard to the elections has all been supplied. Form 33, 34, Form 36, the RTS data, all that has been provided. In my humble submission, my Lord, this is a sideshow. This is a sideshow intended to distract the court and the parties from the actual petition. And this is manifest from the fact that there's a very curious component of this application. If you look at page 15 to page 48 of the bundle, there's a brand new petition in there. There's a brand new petition that has nothing to do with the petition that you have here. Page 15 to page 48. Essentially, you have a notice of motion, and when you read the notice of motion, you can see it is anchored on this new petition. This new petition is essentially stating the IEBC was obliged to undertake an electronic election. And because it did not do so, the entire process is invalidated. Now, that's not in the main petition. So you wonder, what is this new petition? When is it going to be brought? And I think my learned friend, Mr. Ngatia, said when he talked about a metamorphosing case, I guess once the data is produced and they've done the forensic, they will then say, now we have enough evidence to prop up this new petition. So my submission is that this petition is an indication as to what it is that this whole petition is all, application is all about. My Lord, my learned friend stated that the IEBC to undertake an electronic election. There is no such constitutional requirement, and there is no such statutory requirement. There are only two provisions in the law that relate to the use of technology. Section 4M of the IEBC Act and Section 44 of the Elections Act. And those two state that the IEBC shall have the discretion to deploy technology in the management of the election. There is no obligation to conduct an electronic election. And my Lord, in our grounds of opposition, we have set out what are the processes of the 2013 election. And they are all manual. They're not electronic. People marked a physical ballot paper. The ballots were counted physically. So it's actually a manual process, not an electronic one, as they seem to suggest. And our submission is that the role of technology in this election was to add an extra safeguard to the entire process. And the forensic audit sought doesn't help in advancing that question. Let's take the case of the electronic voter identification devices. The affidavit of Dismas Ongondi states that the problem with those devices is that they were delivered late and they were not fully charged. Why do you need a forensic audit to find out that a laptop wasn't fully charged? All you do is plug it and charge it, and you will know that it wasn't charged. What you need to be concerned with is, what was the impact of not using that device in the election? And we are saying that there was a manual process for identification of voters that was robust. So my submission, my Lord, is that this application is a sideshow and a distraction and should be dismissed. And our grounds have also, in our grounds, we've also dealt with the question of the CAN-call server. My Lord, that's another curious request. The allegation by the petitioner is that the IEBC co-hosted its results transmission system with the TNA. Now, that is not true. It's an outright falsehood. The affidavit of Nicholas Nesbitt has stated what is it that IEBC was doing. It had a call center that had nothing to do with the elections for queries. Where do I register? What is the procedure for registration? That call center was hosted by KenCall. The results transmission system was a dedicated system that was not linked. By the time they had filed this, the affidavit of Nicholas Nesbitt was already on record. They knew that the call center had nothing to do with the RTS, but they've weaved a conspiracy theory around it. And that is, again, part of the sideshows that is being presented. So I would urge you to consider our grounds and the respective affidavits and dismiss this particular application. However, should the court feel that there is any document, any equipment in Prayer 2A, in Prayer 2 that is needed for the legitimate exercise of this petition, we're happy to provide the same. We're happy to do so.
Thank you, Mr. Nani. Ms. Ngatia, I think you're next, right? Yes. Hmm? Mr.?
Let me go first for the second respondent.
Oh, yes, sorry. Yeah.
My Lord, this morning when I said the petitioner number 5 really doesn't know the main components of the case, my learned friend took offense at that. But I think really what we are seeing is that a clear evidence of an implosion in that petition. And what my learned friends are doing is a reconstruction of that case. It's a classic case of a fishing expedition. And like all expeditions, we really don't know where it will end. But my Lord, if you look at the notice of motion itself, I don't think that because this is the Supreme Court has powers to issue every prayer a party 6. The Supreme Court, like any other court, and my Lords, I will remind you, I think it's paragraph 65 of your judgment in the Masharia case, is that where a jurisdiction of the court is given, especially a constitutional jurisdiction, the court must limit itself to that. And I think the words you used that now has replaced the S.S. Lillian case. You said the court should not be crafty, the court should not be innovative when you are interpreting your constitution. But my Lord, if you look at this application, I don't think you have jurisdiction to grant these prayers. There is simply no jurisdiction. Look at the provisions of the Constitution this application is grounded on. The first one is Article 10. Those are national values. Can you give an order under national values compelling the first and second respondents to supply the IT system because it's part of our national value? I don't think so. Look at Article 38(2). It says fair, free, and regular elections. It has nothing to do with providing the issues my learned friends are seeking. The other provision is Article 35b, right to access justice. My Lord, the right to access justice is a very fundamental right, but it must be a court of first instance. You must go to the High Court. If you are successful, you come to the Court of Appeal, and then you can come to the Supreme Court. And my learned friends have made, not the petitioner himself, but his principals or his agents have made a similar application in the High Court. And my Lord, there is strike law. It's strike law. This court has said, and many courts have said, that when a party makes similar applications in 2 different courts with different jurisdictions, it is an abuse of court process, my Lord, and this is really what it is. So, my Lord, if you look at all those prayers, whether it is Article 82, 86, there is not one article in the Constitution that will empower this court to force the first and second respondent to give this power. This court, of course, has immense powers when a party rightly invokes its jurisdiction, but this is not one such case. You simply don't have that jurisdiction to compare. My Lord, if you look at the 2 prayers, and I associate myself with my learned friend Nani's submissions, I mean, the prayers they are seeking are really extraordinary. Look at prayer 2. That this honorable court be pleased to issue an order directing the first and second respondent, their services or agent, to deliver to the honorable court. To deliver to the honorable court and do what? When did the Honorable Court ask for these documents? And to all the parties in, within 24 hours, all information, electronic hard copy in relation to the just concluded presidential election within, and my lord, I think what my learned friend Nani says is very important. They have already all this information. They have been supplied with. What is the need for doing a forensic audit? Prayer 3 is more startling, my lord. It says that this honorable court be pleased to issue an order directing the first respondents, servants, contractors, agents, service providers. You can't make order against the parties who are not party to these proceedings. How can you compel our contractors, our service providers, when they have not participated in these proceedings, to be compelled and to give orders? Google Kenya Limited, Next Technology, First Technology, Landtech, my lord. My lord, it's a basic principle of law that you can only make orders against parties who are parties to these proceedings. There are 5 or 6 parties who are not even aware. Of course they are aware, I'm sure they are watching TV, but who are not aware really of the purport of the orders my learned friend are seeking. And my lord, I think, my lord, the court really should also see the real purpose of this. It's an attempt to cannibalize, to vandalize a national institution. When you bring all these documents from 35,000 stations from all over the country, how long will it take? It will take a month or 2. We don't have that luxury. But my lord, this application, as my learned friend rightly says, is premised on a false reading of the law. And that is a signature tone, actually, of this petition. When, for example, they say that the respondent was supposed to provide an electronic tallying system, my lord, just look at page 52. My lords, if you look at page 52 and see the grounds on which this application is premised on, ground number 2, Roman, ground number 3, ground number 4, ground number 5, and I think the most interesting one is ground Roman 14 at page 54. I mean, you'll be lost really about what the real intention of this. Look at 15 Roman when it says that the Honorable Court ought to be empirically informed of the real reason for the failure of the first respondent. My lord, this is an adversarial justice system. It's not an inquisitorial. The court really has no role to play in this matter. It is for the petitioner to prove his case and the respondent is to answer. So, my lord, my conclusion is this application is really an abuse of court process. Nobody, including, I think, the petitioner, really knows the real purport of this. And, my lord, it ought to be dismissed so that we move on, especially in line of the limited time frame we have on this matter.
Mr. Gatia now. Huh?
My lord, I associate myself with the submissions by my learned friends, but I have a few words of my own.
Which learned friends, including Mr. Oduo?
No, the 2 learned friends, Mr. Ahmed Nasil and Mr. Nani. My lords, as I understand it, a petition in this honorable court must be a structured and a targeted case. Targeted to a complaint which the petitioner identifies, and a complaint which the respondent is duty-bound to answer. It is not an open-ended grand Spanish Inquisition. It's a very targeted litigation. When it ceases to be targeted, one gets into the difficulties that we now have. I have looked at prayer number 3. Prayer number 3 is seeking every IT aspect of the electoral body to be provided to the parties and to be provided to the court. what is the nexus of all that massive technological components to the targets which are under inquiry in this case? What is the nexus of us having each and every device that was used to register 14 million voters? And I ask that because, my lords, there is the converse to it. When we get all that material of all the voters who are registered, and which we do not need for the targets that we have, we are also capable of mischief. Is it fair, my lords, for this honorable court to put in the hands of these litigants all the material of Kenyans that were obtained either in the registration process, the registration of voters, we know that's a figure of over 14 million, or the call centers that were received, there must be thousands of them, each and every aspect of that information. While liars, my lords, it has not been demonstrated that that massive information has any nexus to any paragraph of the petition. It becomes therefore very dangerous, my lords, for very omnibus prayers to be made. They can be made in a very inviting manner. A very inviting manner, which the court says, yeah, there's no prejudice. Of course there is prejudice, because it's so omnibus, a prayer, and of course once that prayer is granted, parties are capable of a lot of mischief. Let us look, my lords, at the prayer number 3, perhaps in a little bit more detail. I'll only take a minute or so. It seeks to compel companies which are listed and which are not litigants before you, to compel them to provide certain data. It will be a very odd day in a very advanced legal system as we have for an order to emanate from the highest court in our country, directed to a company which was not given an opportunity to be heard. And here I don't hold brief for any of those companies, but they may have legitimate concerns about releasing confidential information to the petitioner. They have not been heard. You haven't been told that any effort was made to serve this application on any of those companies. My lords, again, prayer number 3, you see all the items that are required, which my learned friend Mr. Nani says is in 7 warehouses. Whereas, again, the prayer is crafted in such a way that even parties like myself or my client will be entitled to have access to that information. My lord, I do not see the purpose of that information when one remembers, as I started, that an election petition must be a focused and a targeted attack on certain complaints that the petitioner has and which are capable of being responded to by the respondents. In some, my lords, there is the aspect of proportionality. Every request as litigants come before you must be proportionate to what we intend to achieve. It will be very disproportionate to allow this omnibus prayer, while liars, there is nothing proportional to the information that will be gathered from it to prosecute the petition which is pending before you. I'll therefore, my lords, request that you now direct us that we do not have the luxury of time. Each one of us could come with a very ingenious application, engage you unnecessarily. Let us now be directed to engage on the issues that arise from the petition, on the material that arise from those petitions, so that we can process these petitions expeditiously. That will be all, my lord.
Thank you. Mr. Kigen.
My lords and your ladyship, we also oppose the application, and we propose to oppose them on 4 grounds. The first one, my lords and your ladyship, is that the application is worded in a manner that is ambiguous and is infinite. My lords and your ladyship, looking at prayer number 2, it requires all information, electronic and hard copy, and it's bottomless. Prayer number 3, my lords, looking at page 50 to page 51, requires all media access control, and very significantly, prayer number D says, each of the laptop computers and or personal computers. My lords and your ladyship, when reflecting on whether or not to grant these prayers, there would be a consideration as to how you will enforce non-compliance in the event you grant the orders. And my lord, the difficulty of enforcing, for instance, the prayer for delivery of personal computers as sought for by the applicant, and the scope of what is used in prayer number 2, all information, electronic and hard copy, my lords, we argue will present insurmountable difficulty in establishing whether or not there has been compliance and whether or not there is contempt in terms of obeying the court orders. For the reason of its ambiguity and infinite nature, we pray that it should not be allowed. The second objection we have, my lords and your ladyship, is that the application clearly, it merely says for audit purposes, both in prayer number 2 and 3. We submit that it is shopping and fishing for evidence. My lords, in respect to this issue of shopping for evidence, the first proposition we have is that it is an obligation on the petitioner, before he determines that he has a petition to present to this court, to have made up and defined the scope of his petition. For him to subsequently come before you and say, assist me to get additional material upon which to mount my evidence, my lords and your ladyship, we submit is irregular and you shouldn't allow. The second one, and which is probably more important for us, my lords and your ladyship, is that if you are to grant the orders and the petitioner's petition gets improved by reason of the information and the material you give them, then my lords and your ladyship, you will have, in a certain way, assisted the petitioner against the respondents in an adversarial situation, my lords. And we pray that you leave us to our own devices and you leave us to shoulder our burdens of proof as is required in law. My lords, the third point I was to raise has already been raised, being that it is expected, my lords, that the natural justice rights of third parties will be respected, and the prayer in respect to third parties who have no audience before the court will not be violated by grant of the prayer sought. The fourth issue we wish to raise, my lords, is that the Constitution and the rules governing petitions have defined the scope of what is expected of the first and the second respondent to be presented in court. And that scope was consciously and deliberately defined, including Forms 34 and Forms 36. My lords, to attempt to expand the scope of what is required to be presented to this court, my lord, we submit would be to be innovative, to use the word of the second respondent's advocate, that you would be acting innovatively on the Constitution when it's not warranted. Lastly, my lords and your ladyship, we submit that considering the time constraints which were deliberately fixed in the Constitution and the rules, with the intention of bringing this petition to an end at the earliest possible moment, this application seeks to frustrate that object, and we pray that you shouldn't allow it. For all those reasons, my lords and your ladyship, we pray that you disallow the application.
Councillor Oduo.
My lord, I must start by saying that all councils have miscomprehended what is sought in this application. But my lord, I'm not surprised because there's a big divide between the analog age and the digital age. I say so with respect in the following arguments. Lord, if you look at the chart that was given by IEBC, the result management system, it's composed of various servers. All activities that were undertaken by IEBC in the result transmission would be on their servers. So it is one central location. They have the server at the headquarters. That's where the logs would be. The only explanation we heard from Mr. Ngondi is that there was a failure due to various reasons. That the people forgot their passwords, the system got jammed. But that's not empirical. The only way this court can be satisfied as to why the system failed is by those logs being produced. And look, they're not bulky documents. I started by making a concession that there have been production of a lot of documents. The Form 34 have been provided. The Form 36s have been provided. The Principal Register of Voters has been provided. The Provisional Register has been provided. The database as a result of the elections has been provided. My Lord, all we are asking for are the electronic logs. And my Lord, there are specific servers. The server at the headquarters where the results were being transmitted to. The server, which was the backup server. We have the server that was at the National Tally Center. We have the server that was at the County Tally Center. And the servers that were at the Constituency Tally servers. These are electronic logs, which can be either be printed out and furnished to the parties. And my Lord, we are not fishing. Those are their own records that will show us why those devices failed. As we have right now, there is nothing empirical to show why those devices failed. All we have is the IT manager saying, look, there was a wrong installation, this did not happen, they were delivered just before the elections, therefore we were not able to successfully test those particular items. Whether or not they worked is an issue.
Is it being denied that the devices did not fail?
My Lord, it is stated that they failed to an extent. That is what is stated. But my Lord, that must be empirical. If the device did connect to the server and there was an error, what kind of error was it? That will be found in the electronic log, specifically the error log. If there was an event that occurred, it would be in the event log. And my Lord, more important, the archives of all these servers would have that information. My Lord, there is no reason why the IEBC or even the respondents who seek to know the truth of why the system failed should resist this application so vehemently. My Lord, on the third parties, like Kenco, they were all service providers to the IEBC. They did not have independent data. The data belonged to the IEBC, but they were providing a service to IEBC. For example, Google, if they were actually transmitting these results, from which server were they transmitting these results? What was the IP number of that server? That is all we seek to know. And we are very, very clear. We seek the logs, the IP addresses, the MAC, and if there was a transmission, that will be confirmed in the log. My Lord, I wish to end by stating this, that the IEBC is supposed to be a neutral party, is a custodian of information, and their obligation under the Constitution is to conduct a transparent electoral process one that is accurate. They must provide full account of every failure or success. And my Lord, lastly, it must be verifiable. How are we supposed to verify the fact that there was a failure of an instrument if we are not able to dig out the electronic log and know exactly what the machine said? It's not a time-consuming exercise, my Lord. These logs can be downloaded in a matter of minutes. And there are only 6 servers that we are referring to, as per their diagram on page 28. And my Lord, for the avoidance of any doubt, by their own chart, we have the server at the headquarters, we have the server in the backup, we have the server at the National Tally Center, the server at the County Call Center, and the server at the Constituency Tally Center. And my Lord, to the extent that they have admitted that there was a service that was provided by Kenco, a log from that server would suffice. My Lord, we are not looking for any equipment to be delivered, because if an equipment or a handset device communicated with the server, it would be there in the server. Those are my submissions.
Before you take your seat, as you're aware, we are supposed to rule on this latest tomorrow morning.
Yes, my Lord.
So just to help me and my colleagues to appreciate the gist of that application, what point do you hope to prove by the forensic audit? What specific allegation in the petition do you hope to prove by this forensic audit?
My Lord, there is a specific pleading that the system as set up was set up to fail, and there was no intention to use the electronic means of transmitting the data from the polling station to the tallying center.
Question from me, Mr. Chengodwal.
Yes, my Lord.
What is your response to the allegation that once you obtain this information, if at all you do, you have prepared what you possibly the other party is proposing to be an intended amended petition? What do you say to that?
My Lord, there is no intention to amend the petition. And my Lord, the rules don't allow it. The time do not allow it. All that will be able to show that contrary to the empirical information contained in the log files, Dismas Ongondi has not disclosed to the court why the machines failed, why the entire result management system failed. That can only be verified by examining those logs. We don't have to look at them. The courts will be able to look at those logs. The logs speak for themselves. It will tell you there was an error because, one, you did not punch in the right password. It will be an error because, one, there was no connection, or there was no attempt to connect from that device to the network at all.
One more question.
Yes, my Lord.
Once you have obtained that information, what do you seek to prove?
My Lord, you'll notice that we've listed down 2 experts to come and give evidence. And they'll be able to walk you through to tell you that this log says this. Contrary to what Mr. Ongondi says, this is what happened. There was a connection, there was a transmission, a successful transmission, or there was no connection. There was no attempt to connect or even transmit this result electronically. My Lord, from Mr. Ongondi's own affidavit, he says there was a 55% success rate in the connections. Where does he get that information from? Why doesn't he tabulate that evidence before us in the form of logs? They are not even annexed to the affidavit, other than a bare allegation that there was a 55% success rate. There is nothing empirical. And my Lord, once again, I wish to remind you that the IEBC is supposed to render a system that is accountable and verifiable. Lastly, my Lord, to put this in context, why is it that on the electronic display screen, the number of rejected votes was initially 300 and something thousand? Where was that data coming from? Does he explain how that transpired? It is only the log on that particular machine, on the display system, that will be able to tell us what was actually happening.
Just a clarification. On that last question, the grounds of opposition deal with that squarely, and so does the first affidavit. Equally, on the 45% transmission, we have exhibited the results that were transmitted from 14,000 polling stations as DO4, the exact ones. And if you enter into that data, you will see each and every polling station and the results that were transmitted. We've also annexed a table breaking down those ones. So when my learned friend says that nothing has been given, it's selective. So what I would urge the court to do is please look at the grounds and affidavits, because we've answered all those questions.
The ruling will be delivered tomorrow. This now. Yeah. Yes, can we now hear Mr. Gatti and Mr. Abdullahi on that issue of the affidavits? Yes, I have. Yeah. And then I have issues as well.
Yes, may it please you, my Lord Chief Justice and my Lords, I intend to present this application very briefly, and I hope in a more interesting manner. We start at the beginning. We should always start at the beginning. We are now dealing with petition number 5. In petition number 5, the electoral areas that are listed in that petition as the areas of controversy are actually 57. 57 constituencies are set out as the areas in controversy. That is amplified in an affidavit sworn by Janet Ongera, and in paragraphs 51, 54, 55, 56, and 57, she sets out all the areas in controversy. The controversies, my lords, I want to summarize this for you, if I could. For example, in paragraph 51, this is the affidavit of Janet Ongera in the petition. The complaint, and this is what I was saying, targeted complaints. The complaint is that the votes cast exceeded the number of registered voters. And that is a good engagement, because that's a complaint that has direct connection with the electoral process. In paragraph 54, the complaint is that there are discrepancies between Form 36 and the final results announced at Bomas of Kenya. Another controversy that we can engage in. Paragraph 55, again, a complaint about discrepancies in Form 36. Paragraph 56, discrepancy in Form 34 and 36. My lords are now quite familiar with these forms. Form 34 is the one that is issued at the polling station. 36 is the one that will be issued possibly at the constituency tarring center. Paragraph 57, results from Nakuru County are different from the results at the tarring center. And paragraph 60 are again material variations. All those are litigible disputes within an electoral process. In respect to all those, my lords, the third respondent filed an affidavit in answer to each and every allegation. We not only joined issue, but we gave a complete answer. And as indicated in the morning, my lords, and I need to say this for your record, the merit of the accusation, the sufficiency of the answer, those are matters which are in your hands. Suffice to say, complaints were made and those complaints were answered. That is where we started. This morning, my lords, a 900-page affidavit was served on my learned friend, Mr. Ken Ogeto, who is on record for the third respondent. It includes another affidavit of the same lady, Janet Ongera. It is paginated when you retire to consider this very fundamental issue. If my lords could go to handwritten page 45, is a schedule, a new schedule of electoral areas, and the complaint this time is a new complaint, is that votes were inflated. Votes were inflated. And that, my lords, contains 58 new constituencies. 58 new constituencies. And even if there is reference to a constituency that was in the first document, this time it is in respect to a new polling station. Because again, my lords are now quite aware that in a constituency there could be even 120 polling stations. So each and every allegation here is in respect to a new complaint and a new electoral area. That goes on between handwritten page 45 to handwritten page 46. At page 47, again, complaint of results that were inflated, now comparing Form 36 with the final results announced at Bomas. That goes on, my lords, to page 48, and it goes on to page 49, page 50, up to, my lords, for brevity, page 54. In total, my lords, the new electoral areas are 122. With specific new complaints. And the question for determination at this stage would be, would this honorable court allow complaints made within time, responded to within time, to be amplified by other complaints made out of time, and which now will force us to respond, and in the process of responding, we respond insufficiently, and then what my learned friends will say is, in respect to the affidavit at page this, that response has not been answered. And it won't be answered because between now and tomorrow, or even the remainder of this week, it will be a scientific impossibility to respond to these new complaints. I go to the law, my lords. As I understand it, there is a specific timeline within which a petition must be filed. For my purpose, my lords, I understand a petition to mean and include all the allegations that the petitioner wishes to have canvassed in that case. It is not a petition part 1 and part 2, it's to be introduced later. It is the entire petition must be filed within time. My lords, within the limited time that we had, we were able to find an authority from Nigeria, the Court of Appeal of Nigeria. This is the case of, we've now made copies available to you. If my lords could turn to page 7 of 11, the pages are printed at the left hand, at the bottom of the left hand, page 7 of 11, and then towards the top of that page, the Court of Appeal cited paragraph 16(1) of the first schedule. In Nigeria, unlike in Kenya, the rules are a little bit more elaborate. They provide that if a person in his reply to election petition raised new issues or facts in defense of his case, which the petitioner has not dealt with, the petitioner shall be entitled, my lords will notice the word, shall be entitled to file in the registry within 5 days from the receipt of the respondent's reply, a petitioner's reply in answer to the new issues. So in Nigeria, it's very elaborate. A petitioner is entitled as of right to file a new affidavit if a new matter has been raised. We go to the second one. The petitioner shall not at this stage be entitled to bring new facts, ground or prayer tending to amend or add to the contents of the petition filed by him. So even in Nigeria, my lords, the petitioner at that stage cannot be entitled to bring new facts. We proceed. The petitioner's reply does not run counter to the provisions of subparagraph 4, and then the paragraph I was looking for, my lords. From the wordings of the above provisions, it cannot be disputed that a petitioner, like a plaintiff in a regular court, can file a reply or defense to meet fresh issues raised in a reply or statement of defense. What a plaintiff or petitioner cannot, and this is the important sentence, cannot do, however, is to raise or introduce yet another fresh or new extraneous something to those raised. I pause, my lords. A petitioner is not entitled to raise new grounds or raise new or fresh or extraneous issues to those he had not raised. And one sees the importance of that, my lords, because if the petitioner is to now be allowed by you, my lords, to raise another 122 new electoral areas, and tomorrow another set of whatever number, then there can never be a defense to this petition. It will be a petition incapable of being defended. Because at every turn of the day, new grounds, new accusations will be made. We go to where we started, right at the beginning, the right to a fair trial. It is a right that the petitioner has, but it is a right that the respondent also has. The petitioner had the luxury of not less than 7 days to craft his complaints into a petition. We had barely 2 days to file a defense to those. To allow new complaints, new accusation, my lords, is not only prejudicial, but it will reach a stage that then this petition becomes incapable of being defended. As I indicated, my Lord Chief Justice, and this is not an exaggeration, it's not possible to respond to 122 new electoral areas in the next 2 to 3 days. It is not possible. We would have to look at all the votes cast at each electoral area, compare that with Form 34, compare that with Form 36 to have a meaningful response worthy of being tendered before you. It is not a defense of we deny. It goes beyond that. It is a denial, and more important, a narrative of why we are denying. We are denying because the votes cast were this, registered voters were this, rejected votes were this. That is how a defense in the Supreme Court must be made. I therefore request, my lords, to hold parties to their bargain, which is not to litigate in piecemeal. You litigate wholesale, you litigate with the petition that you filed. To allow this new petition to be filed, my lords, would be quite unfair. With those remarks, my lords, may I request that you disallow this affidavit. Needless to say, it was filed without leave. Even that courtesy of a litigant to seek leave, the petitioner thought it's not worthy of him. He filed this affidavit, served it on the parties, as if it's a fiat accompli, he must do what he perceives he is entitled to do. The days of any person thinking he is entitled to do things as of right are days of which are long gone. My lords, we all must submit to the jurisdiction and the powers of this honorable court and conduct our cases with the courtesy and the decorum that this court deserves. I would not have said all that, my lords, were it something that I would, within tonight or tomorrow, have been able to respond to. But I am not able to respond to this affidavit within the time span that we have. Unless my lords have any questions, I rest my case.
Thank you. Mr. Abdullahi, I think you're next.
Yes, my lord, I associate myself with erudite and lucid submission by my learned friend, especially on the facts. But my lord, as he likes normally to say, I have 1 or 2 things to say on the law. And my lord, I think the basic premise of my submission really starts with pleadings. And I think it is strike law that a party is bound by his pleadings, whether it is in the Superior Court or a matter of the first instance in the Supreme Court. A party must be bound by his pleadings. In this case, the petition filed by the respondent in petition number 5. And I think petition number 5 raises a number of fundamental issues for this court. When will this case stop mutating, as I said this morning? When will it be confined to a certain perimeters all the respondents can answer to, and we go for trial? And I think that's the difficulty the respondents are facing in this case. My lord, Article 140 is very clear on when a petition is filed. It's a time frame the parties must adhere to. And my lords, if you look at the Supreme Court presidential election petition rules of 2013, they give a framework on how parties should conduct their response. And my lord, let me just take you through a little bit. Rule 2 talks about petitions generally. Rule 6 talks about the filing of petitions. Rule 7 talks about the service of petitions. And Rule 8, my Lord, talks about response to petitions. Rule 8 says, upon service of petition under Rule 7, a respondent who wishes to oppose the petition may, within 3 days of service of the petition, file a response which shall it continues, my Lord. And it says, P, it may be accompanied by a reply in affidavit. Then 2, it says, where the respondent does not intend, it goes on, my Lord. Then, my Lord, the next step is pretrial. There is no provision in the rules of this court for a petitioner to file an affidavit in response to the response by the respondent. There is no rule. But it can raise, my Lord, that issue at the pretrial, like the one we started this morning. If you look at Rule 10, it says, issues for determination during the pretrial. The court shall, at the pretrial conference, A, frame the contested issues, B, consider consolidation, C, give directions, D, suitable directions. My Lord, look at F. Give directions in regard to the filing and service of any further affidavit or the giving of additional evidence. So there's a procedure, my Lord, because I think what the respondents are complaining about is the flooding of evidence without leave of the court, because it changes materially the case that is facing the respondents. If my learned friend will have come to the trial and says that this is the additional evidence we want to adduce, I think it's only fair for the court to invite all the parties and say that if the petitioner wants to expand his case this much, are you in agreement? And everybody will say either yes or no. But the flagrant breach of the rules by the petitioner, and I think my learned friend put it very well, like it is a fait accompli. He decides what to do. He files what documents he wants. He expands his petition as he wishes. I think it's an issue that raises a fundamental issue for this court. When will petitioner number 5 be restrained so that he acts within the confines of the law? But my Lord, as my learned friend rightly says, the case we faced when this petition was filed has changed significantly. We faced only 53 areas. We answered all of them. This affidavit has tripled those. Now, there is about 122 areas. What time will the parties or the respondents have to answer these questions? And isn't that a significant amendment of his course of action in a not provided for? Because he's amending his course of action. He's amending the petition in a manner not provided for through an affidavit. Can a petitioner amend his course of action through an affidavit? I think, my Lord, that is something for this court. I think that cannot happen. The petition cannot be amended surreptitiously through an affidavit. And as my learned friend rightly says, my Lord, this affidavit, which is filed in flagrant breach of the rules of this court, and I think, my Lord, let us hear this from this court. Are these rules to be obeyed, or parties can disregard when they want, and the court will pat them on the back, give them excuses? I think that's some of the issue you will have to address in your ruling. And my Lord, I think this should be the start of obedience of even rules. These are not technical rules. 159 will not come in. When everybody thinks that it's not a rule of procedural technicality. This is a rule of substantive justice. One party is taking the court for a ride. He does what he wants in breach of the fundamental rights of the other party. So, my Lord, my prayer, as my learned friend says, is that this court must exclude this affidavit, so that the petition we go for trial is the original petition that we were served 7 days after it was filed. The animal we are facing today is a completely different animal, my Lord.
Sorry, Your Honors, when this matter came up this morning, I was taken a bit by surprise because I did not know that there was a new affidavit which had been filed. I did check up subsequently. Apparently, an affidavit was left at the offices of my learned friend, Mr. Mohammed Nioga, when his office was closed yesterday on Sunday. And his messenger was telephoned, and he was told, look, come to the office. We want to serve you with some papers. Mr. Nyoga was in a conference with us at Utali College, so we did not know until very late in the evening that this affidavit had been filed. So if the court could give us a few minutes to address it on this particular issue. The address will be made by my friend, Mr. Nyoga, who has been working on this issue.
My lords, my lady, I wish to associate myself fully with the submissions made by my learned friends before me, and wish to add as follows. Lord,
is that okay?
My Lord,
No?
I don't think he can be called after me.
Okay.
For two reasons. One, really, he is not a party to this and he's not been served with any documents relating to this affidavit. If your lordships want to hear him, really, I would not put any fiat.
Okay.
But I do think that, strictly speaking, her and my friend, with due respect, are not parties to this contest. This contest was between the parties in petition number 5. But I leave, it to the discretion of the court. Whatever they think is convenient, I will reply when I'm asked.
Yeah, I think we should allow them to address us, because I think this contest goes beyond the parties that you talked about.
And because we have also consolidated.
Yeah.
I'm also obliged, sir.
It's okay. Is that okay, Judge? Yes. 2 minutes, Mr. Regero?
Yeah, 2 minutes would be sufficient.
Yes.
I'll be very brief.
Okay.
Firstly, as my learned friend confirms, we have not been served. I think in the interest of completeness and fairness to everybody, and now that these petitions have been consolidated, we need to be served. Although they shouldn't rush to do it this evening, it will be subject. The usefulness of that bundle will depend on your ruling. So if it should be admitted, then we should be served. If it is struck out, then we will save valuable time and effort. On the substance of this application, my lords, on my part, I would go on first principles. This, I think, is an outright issue. It is very clear. It is a distilled issue of law. And the first point is, do the rules allow that affidavit that has found its way into the record? Clearly not. If you look, and my learned friends have enunciated on this, I don't want to be repetitive. Nowhere but nowhere will you find provision for the petitioner to file the affidavit that they have done. And to add insult to injury, they don't even bother to seek leave of court if they deigned it, if they thought for a moment that there was necessity to file that affidavit. Connected to that, which is adherence to the rules, it is clear, my lords, that if there is one institution that epitomizes the rule of law and constitutionalism, it is this Supreme Court. You have been steadfast in your observation of rule of law. You have been steadfast in your fidelity to the law. We have seen your rulings. We have seen your decisions. We have seen the rules that you have promulgated over time. And the one common thread is that you are faithful to the rules and you will not allow casual approach to the rules that you have set so elaborately. My submission, my lords, is that do not allow the petitioners to lead you to relaxing that position. You need to be stringent on these rules. The moment you relax these standards, then we, the practitioners, we, the parties, and the cause of justice will be in jeopardy. You do need to enforce your own rules. You do need to enforce the Constitution and all the laws. Third point is that there is a reason why there is an order as to pleadings. It is not done for the heck of it. There is a perfectly good reason. And one of them, particularly when you have tight timelines such as this, is for case management purposes, so that we have all a clear timetable, we all have one bite at the cherry, not 2, 3 at the prejudice of the other side. We can prepare in time, and your lordships have time to deliberate. Now, what is happening is that that timetable is being scuttled by this petitioner repeatedly. They have no regard to the timetables and the rules that you have set. And the question is this court going to countenance that for a moment? Are you going to allow them to get away with it? Related to this is that there really has to be an end to pleadings. If you do admit this, it has been stated that the respondents in number 4 and 5 will need several days, 3, 4, 5 days. We put in not even an affidavit because it is a brand new petition. They now put in a response to that petition, possibly with affidavits. The other side then feels that maybe they need to respond to that response that has come in. My lords and my lady, where will that leave us? You need to streamline this, you need to focus so that we do this business efficiently. The other point is fairness to the other side. The net effect of these tactics, and I think they're deliberate by the petitioner, the net effect is to seriously prejudice the rights of the other parties so that we are not clear as to what targets we are bringing down. These are shifting targets. You think you have the target in your sights, you want to pull the trigger, it shifts. They bring 122 constituencies on top of the other 53. We respond to this. Before we know it, they bring another 60. Surely, in fairness to the other side, this cannot be allowed. In view of these submissions, my lords, I beseech you, let us be stringent, let us be faithful to our rules, to the Constitution, and let the affidavit that has been filed in total flagrant breach of the rules be struck out, those volumes given back to them, and we get on with the serious business of the court. Thank you very much.
My lords and my lady, with your permission, I will allow my senior, Donald Dyer, to address you on that issue.
Thank you very much, my lords, my lady. And because this is the first time I'm addressing this honorable court, please allow me to say good afternoon and to say what a pleasure it is and a thrill as a Kenyan lawyer, as indeed my colleagues, to address this court. My lords, my lady, we are constrained with the same challenges that my learned senior face, in that this application and these arguments that we have had arise out of Petition 5, in which we were not parties, and therefore the parties did not serve us. So all we could do, as my learned senior has also done, is to try and engage in some intelligent listening in the course of this afternoon. So we'll only be in a position to make some general remarks. And the first and probably the most important, my lords, my lady, I'd like to make is that, bearing in mind the ruling that was given earlier this afternoon by the learned Justice Smoke and Wanjala, I wonder whether we are not splitting.
It was a ruling by the...
By the court and read.
I just read it.
Yes, much obliged. And read by learned Justice Wanjala. I wonder whether we are not splitting hairs. My lords, my lady, due to our interesting sitting arrangements, I'm neither able to write nor to type. I type faster than I write. But I think, and I'm sure that the court will avail us with the full ruling. But among the words that I had, summarizing the ruling, was scrutiny of all Forms 34 from each of the 33,400 polling stations, including those of the diaspora vote, scrutiny of all Forms 36 used by the IEBC in tallying the said Form 34s to establish the accuracy or otherwise, and comparing the numbers of registered voters in Forms 34 with those in the principal register. And there were other orders made with regard to the principal register and so on and so forth. So I wonder, my lords, whether or not, in light of that order that has been given, to which all the parties, including the ones that we represent, will be bound by and will adhere to with much eagerness that this is not splitting hairs. My Lord, my sense of what has been said is that we need to distinguish between issue and facts. And my sense is that the issues that the petitioners, both the first petitioners and in this case the second petitioners whom we represent, the issues that have brought us to court are static. The facts, the evidence that is illustrative of these issues is what may have been added. But the issues that brought us to court are static. And I would just also like to point out that one challenge that petitioners have faced, that certainly the petitioners we represent have faced, is the extremely dilatory attitude and approach of the IEBC to providing information, to providing documents that are necessary, not just for the petitioners, but for every voter and for every Kenyan. And if it were not for that problem, I doubt very much we'd be facing this problem where people are trying to table to you all that they can get. Article 81E enjoins the IEBC to, among other things, be transparent, to be efficient, to be accurate, to be accountable, and 86 goes on to carry out its work in a verifiable manner. And it is the failure to do this that at least has led the second petitioners here. And we would not be surprised if the first petitioner faced the same problem, because in contradistinction to the provisions of Article 81, and this will come out as the case goes on, the process has been opaque, it's been clumsy, it's been inefficient, it's been inaccurate, it's been unaccountable to such a level that any result coming out of it is actually incredible. And that is the problem. In our case, in the case of the second petitioners, we only received the documents, Forms 34, Forms 36, the provisional register, the principal register, and the RTS database late in the evening of Friday 22nd. So those are challenges that we did face. So be that as it may, again, and finally, I take a different approach to that taken by my learned senior and my teacher, Ahmed Nasir, as to the application or otherwise of Article 159. And that is to say that in this of all matters, if in this matter that has animated and has grabbed and has caught the attention of all Kenyans, we cannot apply Article 159, in which one can we? Thank you, my lords.
If I may be permitted a short comment. He's made an allegation that the IEBC, which I represent, has been dilatory or dilatory. That is a lie. It's false. We had only 3 days in which to file our response. As soon as I was instructed in this matter, I issued instructions to the IEBC that everything should be made available to council, everything that could reasonably be made available. We worked overnight. We had teams of lawyers at Utali College, sometimes up to 40 lawyers, checking the records, putting them into all these disks and all this technology, and making it available. We met the deadline within 3 days. So this young man should not look up Roger Tesaros, find a word like opaque, and find every other word that means the same, just to show off to this court that he knows a little English.
No, that's not fair to him. Mr. Rebello, there's a question of decorum in court.
I appreciate.
If you are unhappy or you are very angry, don't pour it out here in court.
I'm sorry.
You must respect the council.
I apologize. I apologize. But a comment like that is deliberately intended to insult. And I'm sorry if at this late hour I lose my sense of decorum. We have been very peaceful here throughout. But when somebody stands up at the 11th hour and starts really challenging the conduct of counsel in this matter, that is quite improper as well. And I would have expected that the court would have stopped this young man from making those allegations.
Mr. Rebello, I think you are not making a new point. You have already said enough. I think you could sit down so we proceed.
Thank you very much. I much obliged.
Thank you, my lords. I do believe that as time goes on, the sugar levels are getting down, and hence the reaction of my learned friend. My lord, what Mr. Dare has said is not unlike what we experienced. In fact, on our part, we had to go to court on a petition in order to secure the documents. And if he's not aware, we were given soft copies sometime around Wednesday, late last week, but the hard copies were only served on Saturday in the afternoon. Having said that, my lord, first and foremost, I must say I am very surprised by the application made by my learned friends, but it is understandable in the context of what they want to keep out, my lord. My lord, first and foremost, I would ask us to go through the rules. My lord, the rules were carefully crafted, but when you go through the rules, they talk about filing of a petition, that is Rule 6, and then service of the petition, that is Rule 7. But in filing and service of the petition, the rules don't talk about affidavit. They don't talk about affidavit at all. Then it talks about response of the petition, but in response in the petition, they talk about replying affidavit, my lord. But as is known in the practice of this court and any other court, whenever there is a replying affidavit, there is expectation that there will be a response thereto if required, if any matter is raised in the replying affidavit that requires response. My lord, the rules go at Rule 10 to deal, there is no other mention of affidavits, but at Rule 10, it goes to deal with pretrial conference. And in pretrial conference, it provides for give directions in regard to the filing and service of any further affidavits or giving of the additional evidence. My lord, creative interpretation, response to replying affidavit, not prohibited. We begin on that. Number two, the choice a petitioner has is either to file a response within 3 days to keep within the timetable and give the court an opportunity so that when it comes to the conference, the court may be able to deal with it, or wait until the conference in order to ask for leave. We chose the former, and I think that was in the interest of these proceedings. And my lord, the most important thing in a proceeding of this nature is to take into account that this is a proceeding which is encapsulating the spirit of all Kenyans. And it is important, not only on our side, but on the side of my learned friend, to bring all the relevant evidence which may help your lordships at arriving to a dispassionate decision. So that the only issue which can be asked is that, have we introduced any evidence which is not in conformity with our pleadings in the petition? That is when there is a departure, and that is the route my learned friends have taken, which is contrary to the actual the actual situation, my lords. My lords, therefore, I will start by going through the petition and show you what we have pleaded. And in that respect, I would like to refer your lordships to paragraph 5 of the petition. I'll just read it very quickly so that I don't take too much of your lordship's time. My lord, in paragraph 5, the petition deals with the issue of tallying, and it begins at 5.1 by pleading that the first and second respondent resorted to manual tallying, which was a discredited and abused system resulting in the 2007 arising out of its lack of transparency, accountability, and has been the subject to manipulation by the first respondent's officer. Hence, the necessity to introduce the electronic registration and transmission of results. Then at 5.2, it goes on to say that among the glaring anomalies which were observed in the process of manual tallying from which the first respondent excluded the petitioner's agents were that the results were declared on the basis of unsigned Form 36, multiplicity of Form 36 and variance of entry in some constituencies, alterations on files, and brazen disregard by the first, second respondent of the entries on the files of the constituencies, which were eventually reflected in the final tally of presidential elections results and which were announced without signed verification from 34s. In many polling stations, the valid votes cast exceeded the numbers of registered voters, including, not only, but including. So a couple of polling stations were mentioned, which the respondents had dealt with at that time. Then 5.3 goes on to say, in specific instances, the results in Form 36 disclosed by the first respondent were materially different from the results that were posted in the final tally of the presidential results published by the first respondent. Again, an open pleading saying this included Webuye East and Webuye West. 5.4, there were several instances where registered voter numbers in polling stations were inflated in Form 34, contrary to what was contained in Form 36. This included, and the polling stations are provided there. Then, in quite a number of circumstances, there were more than 2 Form 36 reflecting different returns. This included the constituents as stated. In yet other, there were alterations in Form 36 without acknowledgement, including Kiamba and Limuru. A further analysis of the forms revealed that in certain constituencies, there were more valid votes reflected in Form 36, in Form 34, including Chemuse, Mwen, and Danimoi. In yet other stations, there were different entries in 2 Form 36 submitted in respect of the same constituency, for example, Madeira constituency. In yet the final published result, in yet another, the final published results were materially different from the results reflected in the county tallying, for example, in Nakuru, not to mention the material variations between the verbal declarations made by the various commissioners of the first respondent at the National Tallying Center, allegedly after verification of results, and the final figures which are set out by the first respondent, including those of South Imenti, etc. The above, and this was the conclusion, the above are but a few samples of the many anomalies which obtained as a result of the purported manual tallying. So that, my Lord, there is no pleading where the specific number of Form 34s which were tallied had been presented to the respondents, and only that formed the case of the petitioner. The petitioner merely gave examples of places, a few places, where what he was claiming had been done, had occurred, and left it open to provide any other space, which if the respondents wanted to close that window, their option was by way of asking particulars of any other stations which have not been provided. But they didn't do that. Instead, they responded and in the response, they have taken the position, and that you will find in the affidavit of the second respondent, that their manual tally was perfect, accountable, transparent, and there was no mistake. In response to that, the petitioner has gone through the documents they have filed and disclosed in this court. The Form 34s which have been filed and disclosed in this court, and showed the discrepancies which are even in those Form 34s in this court. And it is the first time in my years of practice where I have had a party objecting to an affidavit analyzing evidence which is part of the court record. Nothing in this, in fact, the majority of this, there are only 67 pages of the various affidavits which have been filed, and I'll tell you what the those affidavits are in respect of. The rest is an analysis of Form 34, which have been filed in this court. And in fact, which indeed, by your earlier decision, referred to by my friend, you have said that you are going to carry out an analysis by the court, an inspection, which we have been invited to, my lord. So what you are being asked is a party files a document in court and is saying, don't look at it, don't comment on it. Then why did they file it? And when we look at these documents, we find that by small tallies, there were additions of votes for one candidate, deduction for another candidate, which were in Form 34, but not reflected in Form 36, and not in the results. And when you take totality of that manipulation, you end up with a situation where the results are well below what was reflected to the public. And we are being told, ignore it, it is a new ground in the Constitution, although the whole Constitution is about voter registration, tallying, and results. That's what the Constitution is all about. The whole of this petition is all about. So that, my lord, first and foremost, the objection is of no basis, and it has been worded generally so that you are not informed as to what is contained in this affidavit. Number two, the only other affidavits which have been annexed to the response is an affidavit by Oduor Ongwen annexing proceedings in respect of a prosecution which was going on and involving Face Technology as it was being awarded a contract. And that was a prosecution in respect of Anglo-leasing. And we are telling the court, is this organization transparent? This ought to have been disclosed. And that is in response to their lack of responding to the issue of opaqueness, which has been raised in the petition. My lord, yet another affidavit which has been annexed is an affidavit in respect of the application for disclosure of data which was part of the application my learned friend argued. But it was in response to the response of Ngondi and the response of, what do you call that one? Response of Nesbitt, which dealt with the issue of transmission of data which had not been dealt with earlier in our affidavit. And lastly, the only other affidavit which was included was an affidavit dealing with a comparison between the total number of voters in respect of the gubernatorial elections and in respect of the presidential election. So nothing new has been introduced by way of this affidavit, which is not in the original petition and which is not among the documents which are before the court. And our wonder therefore becomes, are these documents to be dealt with as merely exhibits introduced for the purposes of entertainment, or were they for analysis? Because we have analyzed them and we are being questioned for analyzing those documents. Finally, my lord, it has to be taken into account that what the law objects to is the introduction of a new issue based on new facts. Evidence is not an issue. and there cannot be an objection predicated on additional evidence on an issue which has been pleaded. There can be no objection on that basis. Indeed, the authority my learned friends were relying on from Nigeria is completely to the contrary. It said, from the wording of the above provisions, it cannot be disputed that the petitioner, like a plaintiff in regular court, can file a reply or defense to meet fresh issues raised in reply or a statement of defense. What the plaintiff or petitioner cannot do, however, is to raise or introduce yet another fresh or new extraneous issues to those he raised. My Lord, we are not raising any issue. We are merely analyzing evidence filed in court, and we are making it easier by showing the areas of evidence where we have disputes. In fact, one area is where we find that from these polling stations, 11,000 votes have been deducted from what was balloted for the petitioner. We have to raise it, and it is before court. Any other issue? My Lord, that is my humble submission. On those grounds, I would humbly submit that this objection has no merit whatsoever. The only conclusion I would make, my Lord, that if any leave is required, my Lord, we humbly apply that we be granted leave for this affidavit to be admitted, as really we cannot proceed with the petition where we put in evidence, the other side responds, and we are disabled from responding to their response, my Lord. Thank you.
On behalf of everybody.
Yes, I hope so. It's a joy to respond to my mentor and teacher, Mr. Oraro. My Lords, again, we start from the beginning. Rule 28 obligates a party who is filing a petition to do certain things. It's an obligation on a party to do certain things, which includes, which includes filing a concise statement or the grounds in support of that petition and all the arguments in support of that petition. It is actually Rule 8. It is obligatory in that sense that it's obligatory in the sense that it requires a party to bring forth his whole case. My learned friend is just about to get the rule for me. Yes, I think we now finally have it. Yes, rule number 8, a petition shall be in Form D set out in the first schedule and shall contain A, a concise statement of the facts, a summary of the grounds of the petition identifying in particular, Roman 1, the statutory provision under which the petition is brought, Roman 2, the extent to which the petitioner contends that the issue under review was based, then C, paragraph C, a concise presentation of arguments supporting each of the grounds of the petition, and of course, the relief that is sought. From that rule, my Lord, or my Lords, it becomes quite clear that a petitioner is supposed to bring forth his whole case. It's the first time, equally, as Mr. Oraro said about his practice, it is also the first time in my practice I've heard that you can do pleadings by examples only. You cannot plead and say these are only examples. You plead your whole case. Having pleaded his whole case, then the next question, and the only question really is, how about the new electoral areas? The defense, as I heard it, is this. Because in the petition there was a general statement which includes then these other 122 electoral areas are only to buttress what was included in the petition. It's the first line of defense. And the second line of defense being, no, we saw documents that were filed, and now we are focusing on those documents. Both defenses in my submission are not available. The two defenses are not available for one simple reason, that the new complaints are fresh complaints. They cannot be ignored and said, because he said includes, it means they are now included in what the petition had referred to. As a matter of fact, my lords, when you retire, I request you to do this. To read the petition says there was malpractices in these areas, which includes this. But the affidavit by Janet, which is part of the petition, specifies all the electoral areas which were the subject of the complaint. And if, my lords, from your perusal, you find that actually that is the correct factual situation, then ipso facto, it will be that the new electoral areas are fresh complaints by the petitioner. And being fresh complaints by the petitioner, it becomes prejudicial to the other parties to be called upon to answer to the new complaints within a night or within hours as soon as we leave here. My lords, I go to the second response, which is that the issue, the evidence has not changed, and the issue is static. The less I say about it, the better. Maybe I deal with the accusation that IEBC is opaque. Only with one sentence, my lord. The Form 34 and Form 36 that were given to the petitioner simultaneously with my client. We were both entitled to those documents. We received those documents on 14th March. Simultaneously, those documents were uploaded on the IEBC website. In other words, my lords, a person following this case in Papua New Guinea can see all the Form 34s that were used in the last general elections. Despite that, an accusation is made that this body is opaque. It is a contradistinction. It defeats my, my sense of opaqueness if you can say that somebody who has uploaded all this information, given all the information, and still accuse him of being opaque. That only needs to be stated to be rejected. Second point, my lords, or third point, the application that was made for leave came far too late. In the sequence or in the scheme of Mr. Oraro's arguments, that was the last application or the last sentence he made, very reluctantly. I come from the school of thought that court rules are not made for jests. They are not made as a jest. They are made to be complied with. You must have seen the reluctance to request leave. It was the last sentence by my learned friend. But I go further. After having argued my application, it is really not open for that application to be defeated because Mr. Oraro belatedly sought leave. Particularly when it is understood to all of us as your practitioners that he could have sought leave informally pursuant to the rules. He had the right to even seek leave informally. He opted not to do so. And as I come maybe to the end of that line of arguments, was he obligated to seek leave? I look at Rule 8 of your rules, my lords. It says, under subheading further pleadings or affidavits, a party may, with leave of the court or with the consent of the other party, lodge further pleadings or affidavits. And that really is not something that is difficult for any one of us to comply with. What do I make out of all this? At this early engagement, my lords, it's important that the rules of engagement are clearly understood. Because if they are not understood, we will not have an engagement that has the parity of arms and the fairness that we all expect from you, my lords. The parity of arms and fairness would have dictated the petitioner to have put forth his entire case within the 7 days. And for the respondents, if they wish to defend it, to respond within 3 days. There is no other avenue open to bring new claims or new complaints. By allowing new claims or new complaints, my lords, the rules of engagement become changed in favor of one party and to the prejudice of the other party. My lords, it's with as much humility that I ask you to implement the rules of engagement, because anything less will lead to a very one-sided engagement. My lords, I request you to strike out this affidavit. Really, there are 50-something electoral areas which are fully covered in the petition, and which some of them are covered in the ruling that was delivered by this honorable court suo motu. Those electoral areas are covered in the electoral areas which are in the petition. Consequently, even for your case management, you need to look at the new 122 and see whether you make similar orders as you had done this morning. It will be quite unfair to go that route. Unless you have any questions for me, my lords, that is all, and I really request that this be expunged from the court record.
Thank you, my lord. Lord, my learned friend submitted, that's Ms. Oraro, that they are merely responding to documents that were filed in court after the petition was filed. My lord, the correct position is this, that the Form 34 and 36 was supplied to the petitioner before the petition was filed. And they were filed in court after the petition was filed. But again, more importantly, we were not ordered, as they allege, to supply the petitioner with Form 34 and 36. We actually offered to supply them after they filed their case before the time indicated in their demand letter expired. And we allowed them to photocopy those forms before they filed their petition. I just wanted to make that clarification because, my lord, there's a little confusion about it. Much obliged.
That is the unfortunate thing with abusing matters of fact in court. We disagree, and my other friend who was doing the case in the High Court is here. But I don't think that is a major issue. My lord, what I would like to clarify is the rule my other friend, Mr. Ngatia, refers to, Rule 8, which requires a party with leave of the court or with the consent of a party lodge further pleadings or affidavit, is the court rules of the court, not presidential election rules. So I just wanted to clarify that, my lord. Thank you.
So we'll deliver a ruling tomorrow on this matter. Ms. Kilonzo.
Perhaps if I may, before my learned colleague submits, when my learned colleague was on her feet earlier on during the day, I had not seen the application that he was referring to. When the court rose earlier on, my learned friend served me with a notice to produce. My lords, in my understanding, a notice to produce is served on a party under the provisions of Section 69 of the Evidence Act, where a party is saying that they have secondary evidence that they want to produce, and they're calling upon the party to whom the notice is served to produce the primary evidence. My Lord, I want to put it on record and perhaps save a bit of judicial time that the Commission has no objection to Ms. Kilonzo producing the secondary evidence that she has.
My Lords and my Lady, I think Mr. Nyamodi misunderstands the nature of the proceedings before this court and the conduct of an election petition. My Lord, if you allow me, I would like to argue my application and he can respond to that application. My Lord, the notice to produce is dated 25th of March 2013. I have cited various provisions of the Constitution, the Elections Act, and the Elections General Regulations, and the Elections Registration of Voters Regulations. In the petition, in the second petition, the first prayer, my lords and my lady, is that in the absence, a declaration that in the absence of a credible principal register of voters vitiates the validity of the presidential election. My lords, we seek that the Independent Electoral Boundaries Commission produces the marked register from each polling station. The complaint, both in the first petition and in the second petition, is that in the compilation, certification, gazettement, and the use of the register of voters, the Independent Electoral Boundaries Commission contravened the Constitution and the law. My lords, Article 38 of the Constitution is very peculiar. Article 38, sub-article 2, provides that every citizen of Kenya is entitled to a free and fair and credible election. Article 38(3) states that every...
But I think for everybody to follow, can we know what application is being argued? We have not seen this application. What is it she's arguing really?
My lord, yes, we have served.
An application? Application dated
No,
when?
it's not an application, my lord. It's
It's
a
what?
notice to produce.
Is it an oral application? I think, let's be very clear. If she is arguing an oral application, she says she is arguing an oral application.
My lords, my
If it's a
senior
written
will have his
application, we need
time
copies.
to respond.
No,
It is my
respond
time
we
to
have no
argue.
application.
He can...
Have you served whatever you
Yes, my lord.
raising?
It is my humble submission that this court, as the court conducting the presidential election material, is entitled to the primary election material that was used by the Independent Electoral Boundaries Commission.
But,
that includes...
Ms.
Yes.
Kilonzo, I'm just asking you
Okay.
whether you have served everybody, because that has been the practice so far.
Yes, this afternoon. This afternoon, in fact, the notices to produce are here. I can see so many copies. It is right here. My lord.
Yes, please.
No.
Can you listen to Judge?
Okay, I would like to say something before we continue. I think there is a small miscommunication. Perhaps we should have made it elaborate. Time is of the essence. And every step you take must be clear to everybody, and everybody must know its consequences. So we saw the notice to produce, and we wanted counsel to explain to the court the purpose of the notice to produce, because this is not an ordinary civil litigation whereby you can do these things at the time for directions in the normal course of a civil action, and where you have a lot of time. And there are consequences that arise by even failure to comply with the notice to produce, because of the perception we have that this notice to produce can have an impact on the time, and actually And the way we understand the marked registers, what they mean, and our apprehension that it may have a consequence on time, we thought this should be discussed by council.
Thank you, my lord, for those directions and your guidance. I believe I can proceed.
Is that clear to other council?
My lords, now that the petitions are consolidated, whatever any party does, it's only fair to serve everybody else, so that we are not caught by surprise. And of course, for good reason. If you were to make a determination, for example, that there wasn't a valid voters register, one of the casualties of that would be my client. So it's important that the rules of engagement are clearly understood. My lords, Mr. Ogeto, who is right over there, who is the advocate on record, and myself have not been served with this notice to produce. Mr. Nyamodi has now given me this copy. It's not fair that these things are done casually. Let's serve. If there are arguments to be made, they are made when every party has notice of what is being argued. As to whether one can mount arguments about a notice to produce, I would have tremendous difficulties, because as of now, we do not know whether the person addressed will produce. It cannot be assumed he will not produce. But that is a side issue. The correct issue is that we have not been served, and I would want to participate in the argument, participate effectively, not by a sideshow of being given a copy by the advocate who is on his feet.
My Lord, can I address the court also a little bit? My Lord, I think if the court really wants to open the floodgates, I think you should open it wide. Yes. Because if my learned friend can, for example, argue such a substantive issue on this document when she has served nobody, I mean, you're opening the floodgates. We will come with all frivolous matters. And I think, my Lord, my learned friend rightly said, let us conduct this matter pursuant to the rules of this court. And this application, I've just seen it, does not cite even one rule of this court. I mean, it's been argued like it's a matter in the High Court, and she wants to proceed with it without serving any of the parties. It has a grave consequence, my Lord, if it's had. If we want to move orderly, I think let all the parties observe the rules of this court.
I think initially, and that was 20th, was it 20th? I think it was 20th when we had a mention.
Yes.
Although we didn't order, but we made it very clear that these documents are served, whatever their merit, but let every council look at them, because this petition is not about two parties. It's about 40 million people. And every council who is here must be heard. And that's why we've been very flexible in actually asking people to respond to applications that they have no direct interest in. So I think in your case, you said you have served. They're saying you haven't served. Make sure you serve them now, and we'll probably hear you tomorrow.
Okay. My Lord, I don't wish to interrupt you. But
it's okay, you can.
Yes.
Yeah.
According to the notices we were served, the respondents have 3 advocates on record, A.R. Rebello and company, Mr. Ogeto, who is here, and Mr. Catwell. When you say service, is there an obligation to serve every lawyer who is in court when there's a firm on record? My Lord, this afternoon, we came with that notice to produce, and I can tell you that Mr. Catwell was given a copy, Mr. Nyamodi was given a copy on instructions from Mr. Rebello, and Mr. Ogeto was given a copy. Surely, that's service. My lords, the first and second respondents have 13 firms on record. The firm of advocates that I chose to serve is the senior most advocate on record, and that is Mr. Rebello.
We assume that you serve, they haven't read, they want to read. Is that okay if we do it tomorrow?
I have no problem.
In the interest of justice, so that.
Yes.
But you're sure you served everybody? Because they are saying they haven't been served.
I served the advocates on record. I cannot serve Hamed Nasir Abdullahi, Mr. Ngatia, Mr. Karori, Mr. Njoroge Regeru. Surely, I can't make 13 copies of the notice to produce when it's only one party. The advocates for the respondents should set their matters in order and tell us who it is that we should serve our documents, because we can't be given that obligation to serve each and every of them. That is all.
If I may again, my Lord, I have had a look.
Yeah?
I've had a look at the notice to produce, my Lord. And with due respect to my learned friend, it cannot form the basis of a hearing before this court. If my learned friend seeks certain information, let her make a formal application. Let that application be supported by an affidavit to which the parties before this court can respond. The notice to produce cannot form the basis of a hearing.
That's a technicality. I think let's look at substantive justice in the matter, right? Everybody is just saying that they want to see it. That's what I understood Mr. Gatia to say, Mr. Abdullahi. And we of course, hear the arguments about rules. But if you get it and you can make the kind of arguments you're making tomorrow, and we dispose of it.
My Lord, perhaps maybe then may I seek leave to file a formal replying affidavit in respect of the notice to produce.
Mr. Nyamudi, sorry.
For purposes of movement, and we have no time, I think what the court is saying is that that notice to produce, or by whatever other name it may be known, has to be served upon each and every advocate. We are not serving firms. And then we are saying that come first thing in the morning or second thing, you will argue that notice, but the respondents will have the right to make a response, including the type of argument Mr. Nyamudi had just made, and this court will rule whether in fact that notice to produce has the effect which Kathy wants it to have. And then we move on, because there is simply no time. That is what we are saying. Is it understandable now?
Just one thing. Yeah, just one thing. To add to what my brother Justice Njala said, I think the way I understood it, and perhaps we all understood it, sometimes you could tell us whether we are on the wrong track, was that a notice to produce has been filed. We are coming for pre-conference trial, pre-trial conference, to set up the management of the case, to set up the cause and management of the case. We didn't want parties to be taken by surprise, or for documents to start being produced and issue of production being argued in the course of the trial. So we thought we put this as one of the checklists. Will anything arise from this notice, which has been placed on record? And then, so that now, if anybody wants to say something, we now, it's not strictly speaking an application. We all know that it's not an application. But then, if it's going to impede or interfere with the course of the hearing, we'd rather deal with it at the pretrial conference than later. So that if it can be, if Mr. Nyambodi, for instance, would say that I have no objection, I can produce, so long as, for instance, he has that option, so long as it doesn't interfere, or it doesn't interfere with the, or it doesn't protract the trial, fine. But of course, we realize that possibly this could also cause an interference with the time. Perhaps other objections could arise. We thought in good faith that we deal with that now than later. We're not treating it as an application. So there'll be no requirement to put in replying affidavits.
I think we are happy to be guided by your clarifications, only that there is that little additional burden on us to serve every lawyer present, because from the quorum you will notice that we are 4 of us appearing for the client Kathy is talking on behalf of. But even as we sit here, the documents that have been served this morning, the whole day, they haven't served me and have not complained, because I appreciate that once Kathy gets it, we have gotten it. So, and we don't represent big clients. They represent the clients who can make photocopies of these documents. However, in the interest of time, and because it is in our interest that we started the hearing of the petition even tomorrow, we are ready and willing to make photocopies and serve these colleagues who are here, if necessary, if we can find a photocopying place this evening. Thank you.
We'll take up this matter tomorrow morning. For 15 minutes should be enough. Yes, all of them. All of you, yes. So, the last thing that we want to do, and of course we are continuing until midnight, so you let us know when you want a health break. The last thing, anyway, is Mr. Ngatia. Did you host your colleagues, and are we agreed on the issues?
Yes, pursuant to your order, my Lord Chief Justice, which made me go out of pocket substantially, we had a very healthy engagement at one of the establishments. We actually saw that we ought to be talking about 4 issues, maximum 6 issues for trial. We agreed at that broad consensus that there will be 4, maximum 6 issues. We were able to draft issue number 1 and issue number 2 and substantially the other issues. I cannot stand before you, my Lord, and say we shall all agree. But at least we have agreed that we will minimize the issues, because the more issues we have, the more of a burden we place on your shoulders. So my request, my Lord, is allow us more time until tomorrow morning. If in the course of the evening we find we can't agree because of adjectives and verbs, then we shall agree that we each file our own set of issues. And then we, of course, agree it is the court that would determine the issues. But I trust, my Lord, it will be more of semantics. It is not anything substantial. And in all probability, we will be able, Mr. Oduol came up with a very good idea, and I'll try to, we shall try to advance that idea. And if our other colleagues agree, then we'll have a joint statement of issues. So that is on course, my Lord.
Have you agreed on who is buying drinks while you finalize?
No, it's got to be another person. It's Oraro. He's our senior.
Okay, tomorrow. So, sorry, I had said that was the last issue. Actually, it wasn't. We will very quickly hear Judge Njoki on the time. You remember you told us how much time you need, and we have considered that, and we will now allocate the times.
And then from 10:30 to 11 a.m. is the health break. 11 a.m. to 1 p.m. we come back to court. We then break for lunch 1 to 2 p.m. Then at 2 p.m. we'll proceed until 3:30 p.m. when we take another tea break. And then we will work from 4 to 6:15 p.m. We have assessed the amount of time that we have because we would like to sit for the hearing in 2 days. That is Wednesday and Thursday. and we want to allow for time for consultations among yourselves, as well as deliberations among members of the court. And therefore, we have said that we will sit for 7.5 hours, or 7 hours, 15 minutes per day, each day. And what we have done is to equally divide that time between, on the one hand, the petitioners, and on the other hand, the respondents. And we have said as follows, that the petitioner in petition number 3, we shall allocate 54 minutes. The petitioner in petition number 4, 54 minutes. Out of the, you see, we have 15 hours in total, the 2 days. So we are now dividing that into, in what we have seen. Huh? Sorry, is it? Can you hear me now? Oh, okay. I thought I could be heard anyway. So petitioner in petition number 3 gets 54 minutes. Petitioner in petition number 4 gets 54 minutes. Petitioner in petition number 5 will get 2 hours and 6 minutes. The first and second respondents will share 2 hours, 6 minutes. If they feel like using the time separately, that gives them 1 hour, 3 minutes each. If they combine, they have 2 hours, 6 minutes. The third respondent has 54 minutes. The fourth respondent has 54 minutes. And the Attorney General has 30 minutes. How you manage your allocated time is up to you. You will determine whether the time is to be used in submissions or you're going to produce your witnesses at that time. We have arranged a time management system. You notice that we have a stopwatch in the court. There is one on this side, there's one at the back, and by the time we start on Wednesday, there will be one in front of the Learned Counsel. And the stopwatch will start flashing as you near the end of your time so that you are able to wind up, so that we do not stop you abruptly. And we try and keep this time so that we allow each party sufficient time to contribute. We have very little time, as you all know, and if the President of the Court allows, perhaps we can extend, but we would prefer, in order to allow also the court time to deliberate, that we keep to this schedule. I think that's it.
So we adjourn until 9 a.m. tomorrow. Yeah.
This is not really, this is not really an application but a request. If you could perhaps reconsider, as I heard, the petitioner, particularly petitioner 4, will have 54 minutes. Petitioner 5 would have 2 hours and 6 minutes. And I'll have to defend that case within 54 minutes. My lords, if you could perhaps relook at it, because even if I were to say only one word in respect to each allegation, it will be impossible to do so. I have to meet, I'm sorry. I have to meet the case by petitioner number 4, petitioner in petition number 4, and petitioner in petition number 5, and they have been given, one has been given 54 minutes, the other one 2 hours, 6 minutes. A lot of that time would be things that do affect my client. It won't be possible to really respond to all those accusations within 54 minutes. If it is possible, my lords. But this is something that we could look at tomorrow. I'm not asking for an instantaneous answer.
Like I said, we have 15 hours. Those 15 hours are divided equally between the petitioners and the respondents. Perhaps you can consult with the other respondents, and maybe those who don't take up so much time can donate some time to you. But otherwise, we don't know where we will get the time from.
We could deduct from the fifth, Mr. Oraro's 2 hours, 6 minutes.
Mr. Ngatia. Mr. Ngatia. Sorry.
Yeah.
You're still on. You're talking.
Say something.
Yes,
very briefly. Actually, the pre-trial conference is actually a dialogue. We are not making orders.
Yes.
So this is the proposal we're making. And if you have better or rather suggestions, like even cutting down on the tea breaks, please tell us.
On my part, my lords, I'll do anything possible so that at least I have some adequate time to respond. Because what I see is from, say, my learned friends, they'll make quite a bit of accusations that will need to be responded. But, my lords, as I indicated, this is not an application, and from the what I have now learned, it's still subject to a bit of adjustment. What I'll do is I'll also engage with my learned friends and see a very fair way of apportioning all the 15 hours that we have. Yes, which may include actually not having very elaborate tea breaks.
I don't know what the status of written submission is going to be, because perhaps that is one way of cutting the time that we are looking for, because we may not be able to go through all decisions that we're going to cite. But if then we are allowed to file those submissions perhaps in the course of tomorrow or after that, and that can help in expediting the matter.
Yes, my lords, I have something small to say too. A couple of things. One is that I think the court has treated us as equal on account of being persons, rather than on the substance that has brought us before you. Because the issue, especially related to petition number 3, is only one, whereas the other petition number 4 or 5 have more issues. Therefore, that equality is actually breeds inequality. 2, we will need the right of reply, I hope, and the way the time has been distributed, I humbly suggest that probably that, I don't know whether you took that into account, because we will be waiting. We might spend our 54 minutes in our submissions and witnesses, then we will not have the time to reply after they have said what they have got to say. 3 is that the 3rd and 4th respondents, I will treat them much the same way I've treated the 3rd petitioner, because most of the allegations, at least our client makes, are allegations against the 1st and 2nd respondents. And therefore, treating them, if you look at actually the way time has been distributed, the petitioners have much less time than the respondents have, yet it is the burden of proof. It rests solely with the petitioners to show cause that they have a good complaint they have brought. So I think, my lords, it is something that we need to consider. Kathy and I believe all of us, are willing to be with you until midnight every day so that we finish this matter. However, we appreciate the other constraints. But perhaps what we could do is, considering these comments we are raising, we can reconsider this timetable tomorrow. Not to reduce the number of health breaks, but to weight each of the parties so that we have sufficient time given to the parties who have the burden of proving their case before you, rather than allocating about 6 or so hours to, maybe more than that, to just one side, and much less to the other side. Thank you very much.
I have something small to say on time allocation, especially in petition number 5. And I think it will be fair to all the parties if we know what is the basis you allocate? Is it 2 hours and 6 minutes to the petitioner? If it is the volume of documents, we want to know, for example, if it is the volume of documents, because the first and second respondents have the largest volume of documents. If it is the weight of the matter, I think we need more information really on this matter, because the first and second respondents, who are the Electoral Commission and the returning officer, cannot be given 1 hour or 50% of the petitioner when there are two distinct parties with distinct set of advocates. We need clarification on that, because as we have been saying the whole of today, there must be fairness, even in time allocation. If you give a party 2 hours and you give the other party who is answering that same question raised by that party 1 hour, I think you are sending a signal which is not good for the hearing of this case. Let us be fair to the parties. I will suggest like this. If it is, I think we have 14 hours, 15 hours. Let us divide it equally between the parties. You can't give certain parties preferential time. It's not just fair, because everybody will see that it is not fair to my client when I'm given half of Oraro's client. There must be a formula, and you must share with us so that we buy that formula. If we don't buy, we see the court is not fair to some of the parties. And I think it's very critical. If you limit the time you give us and expand or give one party unlimited time, of course the case is already prejudiced against some of the parties. So let us have a formula that's agreeable to all the parties. Yes, divide by the number of the parties.
No, that's your formula. We want to give you our formula.
Yes, yes.
and then we can debate around that, right?
I think
yeah.
this is our formula, which we are giving you. We are giving you our formula, and then perhaps you can make proposals, or after you've discussed among yourselves, you come back with another formula. But this was the formula. We have 15 hours. We have divided the 15 hours in half. Half for the petitioners and half for the respondents. So that when you're looking at your time is coming in the half given to the respondents. Then within the respondents, we have divided time, so that the first and second respondents have 2 hours, 6 minutes together. If they want to argue separately, they have 1 hour, 3 minutes each. That's because in our assessment, their pleadings are closely related. Then we have the third respondent who has 54 minutes, and the fourth respondent who has 54 minutes. When it comes to the petition, we've also divided the 7.5 hours. And the petition number 3 gets 54 minutes. The petitioner in petition number 4 gets 54 minutes. And the petitioner in petition number 5, who we think raises more issues, gets 2 hours, 6 minutes. So that's the formula we have come up with, but we are open to suggestions. Perhaps as you're drinking your wine this evening and discussing issues, you can redo and represent a formula to us tomorrow. The only thing we cannot do is that we cannot change the entire time, which is 15 hours.
And just to cap it up, just to assure Mr. Ben Nasser that the court is not sending any signal whatsoever. It was just a time proposal, because we have 15 hours. Yeah.
So, to the contrary, I think the signal was being sent to us, because as far as we are concerned, there's no equality of arms here. We are one petitioner against all these respondents. So there must be equal time between the petitioner and the respondent, and the formula used has given almost double time of what has been given to the respondents. In fact, without opportunity for the petitioner to now reply to whatever the respondents state. So I would suggest that any formula which is adopted must have equality of arms. And the equality of arms is each party before a court is entitled to equal time. No party can be given more time merely because they have multiplicity of numbers. If in the event, the position is that the second respondent is only joined because he's a returning officer, and therefore an agent of the first respondent. The third respondent and the fourth respondent are only joined because they have an interest on the issue. There are no allegations against them. Yet, when you take the total time given to them against the time given to the petitioner is left with almost a quarter of the time. And really, doesn't suggest fairness, suggests that the petitioner has to be on the run to prove his case. He has all these allegations, which he has to prove, and there will be 5 answers against the same allegations. So I would suggest that we think of a much more fairer distribution, which creates an equality of arms between the petitioner and the respondents.
So I suggest that you think through the formula, and we can conclude it tomorrow. Yeah? That's fine. We've given you a formula. We have heard you have other formulas, so let's conclude it tomorrow. If it's dividing equally and you agree that is the case, that's fine with us. Okay? Can we meet tomorrow?
All right.
Terrible. Yeah. Very.